sure do look good, brother.
Woo! How's everybody doing?
It's good to see you guys. I hope everybody's doing well. And listen, don't expect no fucking happy Valentine's from me. Okay? All you people who have somebody can go fuck yourselves. Hope you choke on your fucking chocolates. No, I'm just kidding. I don't feel that way for real. But seriously, I hope everybody's having a great Valentine's. I hope that your significant other is spoiling you and all of that stuff, and I hope that your man fucking hammers nails tonight and everything just gives it to you special. I'm hoping this happens. I mean that from the bottom of my heart. Oh my god.
Oh, here we go.
I think we got a super cat. Super cat. I think we got a super cat. Super cat. Super cat. Super cat. I think we got a super cat.
How dare you?
Oh, Kevin Higgins. Oh, Higgy. Oh my goodness. Thank you so much. My man, what happens when the evidence comes out? You wrong. We'll see about that. No game. We'll see about that shit. Wonder what you're doing today. Fucking sitting around, fucking trying to figure out how to type Happy Valentine's Day. Well, today's Valentine's with an M. Do you like me? I like you. We know what you're doing, Higgy. We know what you're doing. Enjoy it, because hopefully it's your last one. Well, not your last one. But your last one that doesn't take place in an aluminum shower. Anyways, it's great to see you guys, man. We're gonna go over, apparently Aiden, aka Turtleboy, has filed a motion to dismiss. This is massive, folks. Massive. This is fantastic, and I have not read this yet, so there will be a reaction. And I saw that Melanie Little was live about it and went over it, but I didn't get a chance to listen to any of it. I was recording with, oh my god, and I can't think of the name of his channel right now, but I was recording with Andrew Meyer. He's I'm gonna do it raw. You know I'm gonna do it raw, Olivia. I know that yeah, he's an attorney, still practicing. He's a civil attorney. But he's been following and covering the Karen Reed shenanigans, the Karen Reed sham, and he's been doing awesome. And I had the pleasure of finally speaking with him, and we recorded an episode. So it wasn't live, but we recorded an episode that he'll be airing. And as soon as that comes out, I will share it here, and I will share it in the Facebook page as well. So yeah, I'm really excited for you guys to see that, because I really enjoyed our conversation. I really enjoyed it.
Oh, here we go.
I think we got a super cat. Super cat. I think we got a super cat. Super cat. Super cat. Super cat. I think we got a super cat.
How dare you?
Higgy, again, getting my calls on, you know. I need someone to love. I just like anybody else, I need somebody to love. Well, Oh my god, dude. Dude, I'll never take that fucking dude seriously, bro. Like, I'm gonna be so mad if Boston police officer John O'Keefe fell at the hands of that dude. Like, you know how disappointing that's gonna be, dude? Like, that dude of all fucking people, that dude. Like, you know how like disappointed I'm gonna be. Like, at least it's like, okay, you know, at least like if it's like Brian Albert, you know, he's got all this MMA background, but not Mr. Here, play grab ass with me. Play grab ass with me. Oh, look. That girl texted me and told me that she wanted me. Play grab ass with me. Not that guy. I want to see that guy. I don't want to find out that, you know, Boston police officer got bested by that dude. You know what I mean? That's going to make me mad. Fuck that guy. Fuck that guy. Oh my God. And Letteros by Bettero gifted a membership. Thank you so much for that. So grateful. Thank you. Play grab ass with me. Yeah, you just got to get in contact with Cherry if you're trying to like get on my show. Yeah, this guy. Yeah, you gotta get in contact with Cherry, or just message me on the Facebook page. Now, how dare you? Love that shit. So yeah, I had a great conversation with Andrew Meyer and Laney. Really, really cool people, and I really enjoyed it. And I'm really looking forward to the episode, and I'm looking forward to having him on this channel at some point. But dude is like, he's awesome. Like they know what's up. They're not fucking around. They know exactly what kind of shit is fucking going on in Norfolk County. Oh, Hank just filed a motion for sanctions on the defense. Uh-oh. Okay, hold on. Y'all want to have some fun?
Hey,
Excuse me, but why do not I not have Hank Brennan's most recent motion?
because you didn't ask me for it, dickhead.
You're live, by the way.
Oh my god, I'm gonna fucking kill you.
Get me that shit yesterday. Hello.
Why do you do this shit to me? Such a fucking.
All right. Yeah, if I could get that ASAP, I would be really grateful. Thank you.
I'll see how I fucking feel about it.
All right.
Dickhead.
Okay. Bye-bye. You see what I put up with? See what I put up with? Oh man. But before we even get into that, there's no rush for that. Before we even get into that, we're going to discuss Aiden's motion to dismiss, because this is massive, man. This is huge. Like these are the final moves, man. These are the final moves. Better with Bettero. I love it. Great handle. So I'm just gonna get right into it, because this thing's like 42 pages. So I'm just gonna get right into it. And okay. I guess this is how they scanned, but okay. Awesome. I've got Funhouse mirror documents. Cool. Aidan Carney's McCarthy Odell motion to dismiss indictments for lack of probable cause and for the prosecutor's impairment of the integrity of the grand jury with misrepresentations of fact and law. That is, I'd say that is quite the mouthful.
Gay!
Now comes the defendant, Mr. Aidan Carney, by and through undersigned counsel, and hereby moves and that the court dismiss all of the 16 indictments before the court for a lack of probable cause. A, for a lack of probable cause that a crime was committed where the charges implicate only protected speech, and B, the prosecutor's impairment of the integrity of the grand jury by misrepresenting the state of the evidence and the law before the grand jury in a manner material to obtaining the indictments in violation of Articles 1, 10, 12, and 16 of the Massachusetts Declaration of Rights and the First and 14th Amendments to the U.S. Constitution and their progeny as set forth herein. I love that shit. Go, Bettero. And Bradle. I'm not sure who drafted this, but whoever did great. Mr. Carney requests that each indictment be dismissed upon a written and published judicial declaration, and the alleged conduct laid before the grand jury is protected speech under Article 16 and the First Amendment, and that said grand jury presentation was rendered defective by the special prosecutor's material distortions of fact and law, which was motivated by a clear conflict of interest arising from Mr. Carney's investigative reporting on the very individuals who are prosecuting him. So basically, what we've been talking about for the most part, the first point being that it's just a violation of his constitutional rights, despite what Chapter 28, 13A, and 13B dictate. That law itself is unconstitutional. So, he should have never even, this is a violation of his right to free speech and freedom of the press. So, now the other thing here is what I'm really interested in now, is the misrepresentation of facts to the grand jury. So basically they're saying that just to get the indictment, they fucking lied. Just to get the indictment, they fucking lied. In a nutshell, is what they're alleging here. Yeah, I can't wait to read it. I can't wait to read it. Mr. Carney is an award-winning investigative journalist who owns, reports from, and operates a number of news outlets and broadcast over the internet through YouTube, Facebook, X, and his own websites and web pages. Excuse me. He live streams news, investigates matters of public concern, and often breaks stories by conducting investigations into matters neglected by law enforcement before viewers' very eyes live on the air. He offers pointed and unapologetic commentary to his viewers, which number in six figures and cumulatively reach into the millions. He protests, urges boycotts, engages in political hyperbole, satire, rhetorical confrontation, questions investigative targets, petitions the government for redress, and exposes corruption by government officials. He practices advocacy journalism and provides an in-depth, well-sourced factual reporting, often accompanied by a call to action for justice and truth. The indictments against Mr. Carney stem from his investigative reporting on a pending murder case in Norfolk Superior Court, Commonwealth versus Karen Reed. Ms. Reed has been charged in the 2022 death of Boston police officer John O'Keefe. Mr. Carney is an outspoken supporter of Ms. Reed, who strongly believes that she was framed by numerous individuals, including members of the Massachusetts State Police, who are prosecuting him, members of the MSP who are witnesses against him, and numerous civilian witnesses against Reed. Mr. Carney's reporting on the Reed case, including his detailed series Canton Cover-Up, has garnered national attention. At present, Mr. Carney has published 465 articles on the case. His reporting has broken several notable developments on this case. I just literally just went many of which involve the very witnesses he is alleged to have intimidated. Yes. Consequently, Mr. Carney's reporting and advocacy journalism have severely criticized the Norfolk County prosecutors and state police assigned to the Reed case, which in turn has led them to weaponize the Massachusetts witness intimidation statute against Mr. Carney with the intent to silence his criticism of the alleged misconduct in the Reed investigation and prosecution. Indeed, redacted electronic communications illustrate the Commonwealth's intent to silence Mr. Carney by exploiting that fundamentally flawed statute. Shortly before Mr. Carney's arrest for four-month-old conduct, who has referred to Mr. Carney as an outrageously and recklessly texted and other unknown individuals. And I think, are they talking about crusty panties? Is that what's going on? Applicable law, the legal principles to be applied in the instant motion to dismiss indictments concern the law of a probable cause in, A, probable cause in the grand jury, B, impairing the integrity of the grand jury by distorting the evidence in a manner affecting the indictment decision, and C, witness intimidation, picketing, and their First Amendment limitations where speech is implicated, and D, conspiracy. And I've got to remember to come back to this footnote here because this is interesting. They're talking about, let me just see real quick. It's just stuff. Yeah. Stuff that we already know. Yeah, this is stuff that we already know. Now, probable cause to indict. The grand jury performs a dual function of determining whether there is probable cause to believe that the suspect has committed a crime and of protecting citizens against unfounded criminal prosecutions. A bunch of stuff being cited here. I'm just trying to get to the fundamental considerations of fairness require that a court dismiss an indictment where the grand jury receives no evidence of criminality on the part of the accused. That's pretty straightforward right there. Like, fundamental considerations of fairness require that the court dismiss an indictment where, and that absolutely applies here, where the grand jury receives no evidence of criminality on the part of the accused. That is absolutely fact right there. In order to obtain an indictment, a grand jury must be presented with reasonably trustworthy information sufficient to warrant a reasonable person in believing that the defendant had committed the offense charged. Probable cause requires more than a suspicion of criminal involvement, something definite and substantial. Yeah, like you can't just suspect, like you got to know that this dude did it, that this dude actually intimidated somebody and hurting somebody's feelings by asking them valid questions does not count. Sorry. The Commonwealth must include information to support probable cause as to each element of the offense. Although courts ordinarily do not inquire into the competency or sufficiency of the evidence before the grand jury, a judicial examination of whether probable cause existed at the time of indictment is a clear exception to that rule. Here, the First Amendment protects Mr. Carney's speech and opinions about a matter of public concern, such that there is no probable cause of criminal activity. In short, Mr. Carney's speech is protected as a matter of law under the First Amendment and Article 16. Further, principles of third-party liability and their absence in this presentation firmly establish that the Commonwealth has failed to implicate Mr. Carney in any supposedly criminal activity sought to be attributed to him by third-party fellow demonstrators, whistleblowers, or other internet posters or commentators. Impairing the integrity of the grand jury. The second instance warranting judicial scrutiny of any indictment concerns whether the prosecution has misled the grand jury with false or misleading evidence or statements in order to show that the integrity of the grand jury has been impaired, warranting dismissal of the indictments. The defendant must be able to establish that false or deceptive evidence was given to the body knowingly or recklessly for the purpose of obtaining an indictment. I love that. So right here, they're basically saying, in order for us to file this thing, we've got to be able to prove that the grand jury was deceived, that the grand jury was absolutely fucking lied to. So they're saying, we know the rule. Here's the rule. And here's why this applies. Here's why we're filing the indictment. And I can't wait to get to that point, because I love that they're just like putting that out there. Like, just so you know, we already know what our burden is here. And so we're going to meet that burden. That the presentation of false influence that the presentation of the false or deceptive evidence probably influenced the grand jury's determination to hand up an indictment. Let's see this footnote here. Mr. Carney does not imply or believe that any of his fellow demonstrators or internet bloggers or commentators engaged in any criminal activity. In any event, he would not be responsible for any such conduct, and nowhere in the grand jury was any foundation for joint venture liability ever referenced or attempted to be established. I love that. So basically, this is already getting ahead of the game, because if this goes to trial, or when there's a hearing to argue against this motion, right? When it comes time for Cosgrove to argue against this, because it'll be Cosgrove, it won't be Mello, because apparently, according to Cosgrove, God is taking care of the Mello problem as we speak. Sick fuck. But what we're looking at right now is they're basically preparing for the fact that they're going to try to argue anything that, let's say, for instance, I say, anything that his mods say in chat, anything that his mods say on Twitter, anybody who follows Aiden or Turtleboy, whatever you want to call him right now, anybody, he's not responsible for any of that shit. They're just getting ahead of that bullshit argument that they're going to try to prove. They're going to try to argue. They're going to try to sit there and go, well, okay, well, if he didn't do it, his subordinates did. Let me tell you something. I support Aiden. I support Turtleboy. I support everything that he's been doing, but I am in no way speaking for him or on his behalf. I am speaking out on my support for him and what he's been doing, because I know that these charges on him are absolute bullshit. And I believe in what he's done with the Karen Reed case. But I don't speak for anyone, and nobody fucking tells me what to say. Nobody has any control or influence over what the fuck I say on this platform. I take full accountability for every fucking word that comes out of my mouth. And I'm pretty sure that anybody else who has who follows Aiden on any social media platform would probably say the same thing, would likely say the same thing. So, I mean, I know they're going to try to argue that shit. I know they are. They know they are. Betterow and Bradel know they're going to do that. See, Commonwealth grand jury indictments dismissed, blah, 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 blah. Okay. Mere presence coupled with the failure to take affirmative steps to prevent a crime is insufficient for criminal liability. There you go. Here the prosecutor misstated the law to the grand jury and elicited improper opinion testimony from witnesses, conflated protected speech with illegal conduct, and failed to inform the grand jury about First Amendment limitations on the speech sought to be charged. Although a prosecutor maintains discretion as to whether to instruct on the law, when he does, he must refrain from erroneous statements of the law. By providing legal instructions, the prosecutor enables the grand jury to meaningfully apply the facts to the law, thus assisting the grand jury to fulfill its role as a bulwark of individual liberty and fundamental protection against despotism and persecution. Now, I love that too, because what they're saying here, basically is they misled the jury just to begin with. The grand jury. They misled the grand jury to get this indictment to begin with by simply not citing that Aiden Carney has a constitutional right, that he has freedom of speech, that they misled the jury by simply not acknowledging. They misled the grand jury by simply not acknowledging his First Amendment rights. That's amazing. Because I didn't know that, but this is what they're saying here. They're saying that Ken Mello had absolutely the responsibility to make the grand jury aware of Turtleboy's First Amendment rights, and he failed to do it. Let's see. Prosecutor must scrupulously refrain from words or conduct that will invade the province of the grand jury or tend to induce action other than that which the jurors, in their uninfluenced judgment, deem warranted on the evidence fairly presented before them. Here, as well as will be set forth below, the cavalcade of errors and opinions presented impaired the integrity of the grand jury proceeding and warrants dismissal of indictment. So basically, they're about to go down the list of how the fuck, Ken Mello fucked up, and I can't wait.
Right, Charlie? Oh, you popped. You're gonna be famous. Here it is. Stop. This is Ken.
All right. So witness intimidation involving speech is strictly limited to narrow exceptions to the First Amendment. The Commonwealth ignored such limitations in its presentation. The alleged witness intimidation charges concern Mr. Carney's reporting on the Karen Reed case, including the online updates, live shows discussing the case, appearances at demonstrations, and his expressions of opinion about the conduct of certain individuals in connection with that case. The witness intimidation charges at issue depend on certain conditions precedent, such as evidence that the alleged offender intended to mislead, offer a witness anything of value, threaten, harass, and attempt to cause emotional or economic harm. Whoever threatens, etc. However, the First Amendment in Article 16 limit these potential violations when the alleged means of the crime is a person's speech. Okay? So, when it comes, like, meaning those things listed. Okay. Anything of value, threaten, harass, or attempt to cause emotional or economic harm. Anything that comes out of your face verbally does not fall under that category. That is not applicable. Your speech is protected regardless. That's what that's saying. You say whatever the fuck you want. Under the Constitution, you are allowed to say whatever the fuck you want. That's what that boils down to. You don't get to say, oh, well, you know, his words hurt my feelings. He asked me questions and he wouldn't stop asking me questions. And so now I'm hurt over it. I'm suffering emotional distress. Too bad. Too fucking bad. Okay. Amendment in Article 16 limit these potential violations when the alleged means of the crime is a person's speech. The Constitution demands that content-based restrictions on speech be presumed invalid and that the government bear the burden of showing their constitutionality. The carve-outs where speech may be regulated are few and narrow. In light of substantial and expansive threats to free expression posed by content-based restrictions, the court has rejected as startling and dangerous a free-floating test for First Amendment coverage, balancing of relative social costs and benefits. Instead, content-based restrictions on speech have been permitted as a general matter only when confined to the few historic and traditional categories of expression long familiar to the bar. Among these categories are advocacy intended and likely to incite imminent lawless action. And yeah, it's just citing a bunch of stuff here. Hold on, I gotta read that. Imposing some limits on liability for defaming a private figure. Speech integral to criminal conduct. So-called fighting words, child pornography, fraud, true threats, and speech presenting some grave and imminent threat the government has the power to prevent. Although a restriction under the last category is most difficult to sustain, the categories have a historical foundation in the court's free speech tradition. The vast realm of free speech and thought always protected in our tradition can still thrive and even be furthered by adherence to those categories and rules. Here, the Commonwealth merely alleges that the Reed witnesses and investigators suffered emotional or economic harm and or were placed in fear by Mr. Carney's exercising of his First Amendment rights to report, question, demonstrate, and advocate on important matters of public interest, including arguments advanced in the Reed case that she was framed by the very people Mr. Carney is accused of causing emotional and economic harm. The First Amendment does not cease to protect the journalist's non-threatening opinion simply because such speech allegedly has caused economic or emotional harm to witnesses or other related persons under that statute. If anything, it is precisely in these situations in which the First Amendment must protect the person's right to report on and express their opinion on a matter of public concern. I am going to read that again because I absolutely love it. The First Amendment does not cease to protect a journalist's non-threatening opinions simply because such speech allegedly has caused economic or emotional harm to a witness or other related person under this statute, meaning that the First Amendment still protects Turtleboy regardless of the fact that his words have caused economic or like caused someone to not make as much money or cause someone's fees to be hurt, it doesn't cease to apply to him. The First Amendment still protects him. Doesn't matter if your fees are hurt. Doesn't matter if your business is a little hurt too. Doesn't matter. And it's also saying here, if anything, if it is precisely in these situations in which the First Amendment must protect the person's right to report on and express their opinion on matters of public concern. That's pretty self-explanatory. But in other words, it's saying that's exactly these situations. Basically, what Turtleboy is being charged with, why he's being charged, those things that they're calling a crime are exactly what the First Amendment was designed to protect. That's what they're stating in this motion here. Exactly what the First Amendment, precisely to quote, what the First Amendment was designed to protect. That type of speech, the very speech that Turtleboy got locked up for. Well, got charged with. Alleged harassment by speech, which purportedly causes another economic harm or emotional injury, which impedes or otherwise interferes with anyone connected to a proceeding or a proceeding itself, assuredly is protected speech by the First Amendment and therefore unconstitutional. Yeah, that's it. Like, I fucking love this shit, dude. Glenn Lake, thank you so much for becoming a member. Let me check these real quick. Did I bite him? Yeah, I bit him. I was gifted this now. A real member. Right on. Cool. Thank you so much. And Sharon, thank you for the super chat. Jen McCabe told the 911 that Officer John O'Keefe was there a few hours. How could she know that if she just showed up there? Exactly. That's one of the many inconsistencies in Jen McCabe's bullshit story. So it's real funny here too, because if this does go to trial, and I suspect it will, but if this does go to trial, a jury's going to get to see the footage of these so-called intimidated witnesses acting not so intimidated time after time. I mean, we're going to see screenshots of text messages. We're going to see video footage of Chris Albert threatening Turtleboy. We're going to see Jill Daniels assault Turtleboy. I mean, it just goes on and on. So, I hope that this doesn't go to trial, but when it does, because I think it will, I'm going to be stoked to watch a jury see this shit. So yeah, that's where I'm at. It's the same thing with Karen Reed. I hope the case gets dismissed, but I'm stoked to see what happens at trial if it does go to trial.
Oh, here we go.
I think we got a super cat. Super cat. I think we got a super cat. Super cat. Super cat. Super cat. I think we got a super cat.
How dare you?
Scooter 54, thank you so much. I appreciate it. Will okay. That's the best I could do to read that. Appreciate you. So let's keep reading, shall we? Whereas here, words or expression from the basis of the alleged violation, only true threats of fighting words can be the target of the statute. Unquestionably, all of Mr. Carney's opinions and expressions are exempt from the statute because they are not true threats of fighting words. In these circumstances, the Massachusetts witness intimidation statute, blah, 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 which prohibits the causing of economic or emotional harm through non-criminal speech, aside from true threats or fighting words, is unconstitutional on its face and as applied to Mr. Carney. And I like that word, on its face. That's got better written all over it. Well, no, I've heard Bradle use that too. In Snyder versus Phelps, the U.S. Supreme Court illustrated how the First Amendment protects a speaker even where repulsive, non-threatening speech may have caused substantial emotional harm to another. There, the family of deceased Marine Lance Corporal Matthew Snyder filed a lawsuit against members of the Westboro Baptist Church who picketed near his funeral while displaying signs that said, "Thank God for dead soldiers and fag troops." Wow. Well, I should read that again. Sorry. "Thank God for dead soldiers," and other signs that said fag troops. I didn't want to read that all as one. In reversing an intentional infliction of emotional distress judgment for the plaintiffs, the Fourth Circuit Court held that this highly offensive and cruel speech was still protected by the First Amendment, notwithstanding the distasteful and repugnant nature of the words. Furthermore, the Supreme Court has recognized that speech on matters of public concern is at the heart of the First Amendment protection. The First Amendment reflects a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. That is because speech concerning public affairs is more than self-expression. It is the essence of self-government. Type a 1 in the chat if you are robust and wide open on this Valentine's Day. Accordingly, speech on public issues occupies the highest rung of the hierarchy of First Amendment values and is entitled to special protection. Internal quotation marks omitted. Despite the abhorrent and gut-wrenching nature of the picketing, the fact that it was peaceful, i.e. non-criminal, focused on a traditional public forum, a public street, and addressed matters of public concern. The picketers were shielded from liability for infliction of emotional distress for their speech. Jesus, I didn't really mean literally for you guys to type a 1. Like, Jesus. Okay, Team Brittany. Wow. Okay. Somebody help her out with that. And thank you to all my mods for being here, man. It means a lot. And everybody else for being here too. Yeah, this is fun shit because that doesn't even apply. That doesn't even apply to Turtleboy, dude. That doesn't even fucking apply to him. Because there's nothing so hateful and abhorrent. Well, there's but not anything that he's been charged with. But even still, you know what I'm saying? Like saying shit like, "I fucking hate your guts. I'm glad you're fucking dead." That kind of shit that makes people so fucking mad and goes, "Oh my God, Turtleboy's such a terrible person." Okay, well, you have every right to dislike him for it, but you don't have any grounds to say that there's reason to lock him up for it or charge him with a crime for it. He didn't commit a crime. That's the bottom line here. That's what matters. Now, me personally, I don't give a shit that Turtleboy talks like that. As a matter of fact, it entertains me, makes me laugh. I'm not the one who's going to have to face Jesus when his time comes. Okay? It's not going to have nothing to do with me. So therefore, I'm entertained by it. I enjoy it. I encourage it. I support it. Fuck yeah. Love that shit. Just because maybe I wouldn't do or say certain things that he does doesn't mean that I'm not absolutely totally entertained by when he does it. So, I openly admit this. I take pride in this. I take pride in this. There are some people who say shit, some people that I like, who say shit that I fucking hate. And I simply like them because I admire them for having the balls to fucking say it. That's a fact. So, I mean, and that doesn't even apply to Turtleboy. I like Turtleboy. That's my boy right there. We're good. But, I mean, just because there are certain things that he might say or he might do, I mean, that doesn't mean just because I wouldn't do those things, it doesn't mean that I don't support his right to do those things. I will always support his right to do those things because he has the right to do them. And because he has the right to do them, I'm not going to fucking, try to shut him up. I don't try to shut anybody up. And if it's something that really bothers me, because that's the other thing. Like, let's take Bullhorn Betty, for instance. There's a whole fucking subculture corner of the true crime community, the crama community, that hates this woman. They hate Bullhorn Betty. And they talk about her, and yeah, she's being charged with certain things. I haven't really looked too deeply into what but here's the thing is, I have always criticized Bullhorn Betty because what she does is fucking gross. What she does is she accuses parents of missing kids of crimes when there's no evidence of it. And I would always speak out against this. But here's the thing. I have always maintained that even though I don't like it, she has the right to do it. Now, I'm not saying I don't like that she has the right to do it. I'm saying I don't like what she says and what she does. So I exercise my First Amendment right to say what I think about it. And if I felt that way about Turtleboy, I would do the same thing. But I would fight for his right to say it. And I would absolutely fight for Bullhorn Betty's behalf to be able to say anything that she wants. Period. And I don't give a fuck what anybody thinks about it. And I've always maintained that. We're not talking about likes and dislikes here, people. We're talking about your basic fucking human right that is awarded to you by our forefathers and their draft of the First Amendment. That's a fact. That's it. It's what it boils down to. Has nothing to do with how I fucking feel about nothing. You get to say whatever the fuck you want as an American. Bottom line, period. The First Amendment awards you that. And if I fucking hate your guts, I love that right so much that I would fucking die on a hill to protect your right. Even if I fucking hate your guts, I would die on that hill to protect your right to free speech. It's got nothing to do with how I feel about you. It's got to do with how I feel about my rights and yours and everyone else's. In O'Brien versus Borowski, the Supreme Judicial Court addressed the Massachusetts criminal harassment statute and its inherent conflict between the protected speech of a defendant and its possible impact on an alleged victim. The court held that the illegal harassment was limited to fighting words, and true threats, and interpreted the meaning of fear to mean fear of physical harm or fear of physical damage or property. In other words, the SJC has made it abundantly clear that an individual's claim that another's non-threatening speech has caused her to suffer emotional or economic harm, or that they are in fear of non-criminal consequences, may not be criminalized under the First Amendment. The O'Brien court decisively held that allegedly instilling subjective fear in a person does not give a prosecutor a basis to charge them. That's it. I mean, just because somebody feels scared because your words hurt my feelings and now I'm scared, you don't get to fucking charge somebody for that shit. No, somebody does not deserve to go to jail because you feel a little scared. That's not what America's all about. Independence, individual independence. It's not just your freedom of speech and you're allowed to make however much money as you're allowed to make because this is America. That's not all there is to independence. Independence also means, on the other side of that, you're on your fucking own. This is the land of independence. You're on your own. You are accountable and responsible for your own shit, including your feelings. I am not responsible for your fucking feelings. Turtleboy is not responsible for your fucking feelings. Simple. An intent to cause fear, however, is less certain to be consistent with a true threat unless we narrow that it is that must be feared. As the United States Court of Appeals for the Seventh Circuit noted, there are types of threats that may contain ideas or advocacy, such as a threat to picket an organization if it does not yield to a demand to take some social or political action. Such a threat may cause a fear of economic loss, of unfavorable publicity, or of defeat at the ballot box. But such fears cannot be enough to make the threat a true threat that may be prohibited as civil harassment under the First Amendment and Article 16. There is nothing in the language of the act or in its legislative history to suggest that the legislator intended fear to mean more than fear of physical harm or property damage, and such a limiting interpretation would effectuate the legislative intent to confine and prohibited speech in the act to constitutionally unprotected speech. Therefore, we narrow the meaning of fear under the act of fear of physical harm or fear of physical damage to property. So basically what it's saying is, the only thing that applies as far as fear goes, where Turtleboy's First Amendment doesn't protect him, is if he has said something that directly that legitimately puts you in fear of physical harm. Like if Turtleboy threatens your physical well-being by saying, I'm going to do something to you, or says, I'm going to slash your tires. So unless Turtleboy says, I'm going to come over and smack you in the face, or anything worse, or I'm going to slash your tires, or break something that belongs to you, or steal something that belongs to you, unless those things happen, anything Turtleboy says is protected under his First Amendment rights. That's it. And I haven't heard Turtleboy say one fucking thing to threaten someone, to state that he was going to cause physical harm to another. I have never heard him do that. And I have never heard him say that he was going to take someone's property and damage it or steal it or do something to it. Never have I heard these things come out of Aiden's face. Laulene's in the chat. I love it. What's up, Laulene? The Commonwealth also elicited conclusory testimony. I don't know. That certain complainants such as Elizabeth Proctor and Juliana Nagel felt threatened. A threat is a legal term as defined under Massachusetts law and requires 4 elements as set forth in the model jury instruction. Threat to commit crime. The defendant is charged with having threatened to commit a crime against a person or property of another. Threatening a person with a crime against his or her person or property, a person by threatening a crime against someone else or their property is itself a crime. In order to prove the defendant guilty of this offense, the Commonwealth must prove 4 things beyond a reasonable doubt. First, that the defendant expressed an intent to injure a person or property of another now or in the future, which is what I just described. Second, the defendant intended that his or her threat be conveyed to a particular person. Third, that the injury that was threatened, if carried out, would constitute a crime. And fourth, that the defendant made the threat under circumstances which could reasonably have caused the person to whom it was conveyed to fear that the defendant had both the intention and the ability to carry out the threat. Massachusetts District Court Model Jury Instruction, blah, 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 January 2013. The third element demonstrates the lack of probable cause to sustain indictments on such a theory. Mr. Carney's speech did not threaten injury from a crime and therefore do not run afoul of the Borowski rule. Rather, he expressed his opinion and common sense conclusion that people who lie may experience harm and discomfort, but he never threatened any criminal action whatsoever. It's a fact. At least I never heard it. In any event, under the First Amendment, even literal threats are limited as a basis for prosecution unless they constitute true threats. In Watts versus the United States, Watts at a public rally expressing his opposition to the military draft said, "If they ever make me carry a rifle, the first man I want to get in my sights is LBJ." He was convicted of violating a federal statute that prohibited any threat to take the life of or to inflict bodily harm upon the President of the United States. The Supreme Court reversed, interpreting the statute with the commands of the First Amendment clearly in mind. The court found that Watts' speech was protected under the First Amendment because he had not made a true threat to assassinate President Johnson, but instead had indulged in mere political hyperbole. If a legal definition must be affixed, the words qualify as political hyperbole, where, in light of its context, did not constitute a knowing and willful threat and was protected speech. Now, this is going to piss some people off, but the example I'm going to use here to compare that is just going to entertain me, really, because I know it's going to piss some people off. But so this Watts guy, let me read his words again. Say, "If they ever make me carry a rifle," meaning the government, "the first man I want to get in my sights is LBJ." Now, that is hyperbole, and it does come off as kind of threatening. But technically, he didn't hyperbole. Okay, whatever. Y'all know I can't read. Hyperbole. Okay, y'all are saying different shit. I'm just going to keep saying hyperboil. Hyperboil on the ass of democracy. No. So this dude never actually threatened to kill the president. This dude never actually threatened to do any harm to Lyndon B. Johnson. He said, if the government ever drafts me, puts a rifle in my hands and makes me, he said, the first person I want to get in my sights is LBJ. Which means that the only thing he said was, I would like to just get him in my sights. You know, maybe he's satisfied with just that. Maybe he's perfectly satisfied with going, yeah, man. All right. That's good. I'm going home. And that's it. But that's not threatening the life of the president. It just simply isn't. It comes off that way, but it's not even a threat. It's just he's expressing a fantasy. You can't convict somebody on having a fantasy and expressing it out loud. You know what I'm saying? Like, somebody could say, man, I'd really like to, choke that person to death, right? They could say that, for example, man, I'd really like to do that. But that's not a threat. Unless he says, I am going to choke that person to death, unless they say those words or something just right along those lines, unless those words are basically showing you intend to absolutely cause physical harm, then that's it. Now, the example I'm going to give, same thing. Because a lot of people went up in arms. A lot of people who love to talk about free speech wanted Kyle Gass from Tenacious D to get locked up. Remember that shit? Y'all remember that shit? I'm talking to some of y'all who thought that Kyle Gass should have been locked up because he said, he blew out his birthday candles on stage, and said, next time don't miss, in regards to Donald Trump being shot, technically. So I remember going, was it nasty? Was it gross? Is it enough to make Tenacious D fans who happen to be conservative or anything just simply go, I don't like Tenacious D anymore? Perfectly justifiable. You have the freedom to feel however you want to fucking feel. But he didn't commit a crime. And a lot of people were out there saying, oh, he should be charged. Charged with what? Having an opinion? I mean, it just wasn't appealing. Exactly, Lauleen. Oh my God, Robin G gifted 5 membership. Okay. Yeah, I'm trying to keep this moving here, folks. Thus, the offense of threatening to commit a crime only reaches cases of true threats. The term true threat distinguishes between words that literally threaten but have an expressive purpose, such as political hyperbole, and words that are intended to place the target of a threat in fear. See Watt Super. The term true in true threats distinguishes jests, hyperbole, and other statements that in context do not convey a real possibility that violence will follow. Applying recent U.S. Supreme Court case Counterman versus Colorado, holding that the First Amendment also requires the state to show that the speaker consciously disregarded a substantial risk that his communications would be viewed as threatening violence before it may punish him for conveying a true threat. And then citing the Watts case again. Not that Watts case, this Watts case. The term true threat has been adopted to help distinguish between words that literally threaten but have an expressive purpose, such as political hyperbole, and words that are intended to place the target of the threat in fear, whether the threat is veiled or explicit. Thus, Mr. Carney's opinions may not be criminalized under a theory that he threatened anybody because his speech clearly does not constitute true threats. Here, All of Mr. Carney's outlandish statements set forth in the Commonwealth's presentation are well within the realm of political hyperbole, as well as satire and opinion, given the context and the conditional nature of the commentary. The Supreme Court in NAACP versus Claiborne Hardware set a virtually unsurmountable bar protective of fiery public speech, where they found that the public threat to break necks of anyone violating the NAACP boycott was political hyperbole, and within the speaker's First Amendment rights to rally his audience to his cause. Oh my God, Jedi Jess, thank you so much. It's pronounced like hyperbole. Oh my God, that was so helpful. Thank you so much. I appreciate it. The boycott was politically hyperbole and within the speaker's First Amendment rights to rally his audience to his cause. Massachusetts courts have also addressed the First Amendment protections, requiring Massachusetts judges to read statutes constraining political speech. Consistently, Manolo M versus Commonwealth. Sorry, when I hear the word Manolo, I think of Scarface. Manolo. Oye, Manolo. In Manolo, the juvenile defendant was prosecuted under a statute prescribing the incitement of rioting. The SJC Justice Kafker writing held that Brandenburg versus Ohio limited the Commonwealth's proscriptions, I guess proscriptions versus prescriptions on political speech. Brandenburg involved a statute prohibiting persons who advocate or teach the duty, necessity, or proprieties of violence as a means of accomplishing industrial or political reform, or who publish or circulate or display any book or paper containing such advocacy. The Supreme Court held that the constitutional guarantees of free speech and free press do not permit a state to forbid or proscribe advocacy of the use of force or law violation, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. For example, gathering people in front of the courthouse in numbers, that's not inciting anything unlawful. Gathering people outside of the courthouse, thank you for that, Sherry, by the way. There we go. Gathering people outside of the courthouse to say, hey, let's storm it and start trashing everything and hurting people, well, then that's different. That's different. But Turtleboy never did that. Turtleboy said, let's show Karen Reed some support in numbers outside of that courthouse. Rolling rally. Let's all get together and go on a rolling rally where we protest and exercise our First Amendment rights to protest the fact that Karen Reed is being wrongfully prosecuted, wrongfully charged, wrongfully prosecuted, and the people who know the truth are not speaking up. So let's speak out in front of their homes, out on a public street, and express our disapproval of this. That is not a crime. He's not saying, hey, everybody storm their house, light their houses on fire. He's not saying that shit. He's not saying anything like that. So he's not inciting any crimes. He's inciting people to exercise their freedom of speech, which some might use a different word, such as inspiring. Inspiring. Because when it comes to something as beautiful as your right to say whatever the fuck you want, however the fuck you want. That beautiful thing, I think, merits a word like inspiring instead of inciting. I like the idea that people were inspired to go express themselves, because it's a beautiful thing to be able to speak your mind and do it freely. It's a beautiful thing. A statute which falls to draw this distinction impermissibly intrudes upon the freedoms guaranteed by the First and 14th Amendments to the United States Constitution. It sweeps within its condemnation speech, which our Constitution has immunized from government control. The Manolo Court analyzed the juvenile speech and found the same limiting principle obviously applies here. The same limiting principle obviously applies here as well. There was no evidence before the grand jury that Mr. Carney called for imminent lawless action. As opposed to engaging in satire, political hyperbole, and protected opinion. Viewed in context and in light of the arguably more direct and alarming protected statements in the case law cited above, Mr. Carney's expression and advocacy are clearly political hyperbole and protected speech, and cannot, from the basis to find probable cause, that he committed witness intimidation. Put simply, Mr. Carney did not urge imminent lawlessness action, and therefore the speech is protected by all the foregoing precedent. Thus, the indictments lack probable cause that Mr. Carney committed witness intimidation. To hold otherwise will afford the government authorities prosecuting Reed Carte Blanche, Carte Blanche, to continue, I know that term, to continue their disturbing pattern of exploiting the witness intimidation statute to suppress any speech that is critical of their conduct in the Reed case in the form of dubious content-based prosecutions. The statute is applied to Mr. Carney. The statute as applied to Mr. Carney plainly violates the First Amendment. There it is, right there. It's what I've been saying. And I said this the very first time that I started covering Turtleboy's charges, right after he was charged, probably the same day. I was like, what law is this? I'm almost positive it was the first out of the 5 live streams where I went over all of his charges. And I was like, how is this law constitutional? How in the fuck is this law in any way constitutional? This chapter 28, 13A, 13B. Let's see. Jenny Lee, 43, member for 1 month. Oh my fucking God, I can't listen anymore. Hi, hyperbole. Stop. Okay. All right. Thank you. Appreciate you. Oh my God. The statute, as applied to Mr. Carney, plainly violates the First Amendment, which requires the court to dismiss the charges against him and determine whether a narrower interpretation saves it to conform to the First Amendment. This is exactly what the Supreme Judicial Court noted it would do involving the closely related criminal harassment statute in Commonwealth versus Welch, and what must happen here. In Welch, the court reversed a criminal harassment conviction and noted that if it was presented in the future with a speech case that contravened the First Amendment, it would be obligated to consider the statute and narrow its meaning to only proper constitutional parameters. Dude, we're not even halfway through this, y'all. We believe the legislator, in carefully crafting the statute, intended the statute be applied solely to constitutionally unprotected speech. Any attempt to punish an individual for speech not encompassed within the fighting words doctrine, and within any other constitutionally unprotected category of speech would, of course, offend our federal and state constitutions. We decline to narrow the statute by engrafting onto it a savings clause or other limiting construction at this time. Should the Commonwealth attempt to prosecute an individual for speech that is constitutionally protected, we would have no hesitation in reading into that statute such a narrowing construction to ensure its application only to speech that is accorded no constitutional protection. Yeah, and I have to read through this whole thing, folks. It's too well written for me to not show it that kind of respect. Because this is so important. This is unbelievably important. Turtleboy's case is, if you're not understanding just halfway through this motion why this case is so important and why it's so important that Aiden's case be either thrown out or he's acquitted of his charges. It's incredibly important because citizens of Massachusetts, your free speech is in danger. This case, if he gets a guilty verdict, then they could take away someone else's free speech. They could charge somebody with some bullshit charges and then cite this case. It's very dangerous. So, in some ways, one could argue that this case is even more important than Karen Reed's case. I would not agree with that. I'm just saying that some might argue with that because it depends on where their passions lay. But I'm of the opinion that your rights are your rights, period. And both are equally very important. The only difference is what's at stake here versus what's at stake for Karen Reed, definitely exceeds what's at stake for Turtleboy here. Her life is at stake here. And in a way, Turtleboy's is too. He's facing a lot of prison time. For what? Because Chris Albert's got some pull. You know what I mean? Yeah, his emotional sanity's at stake, but I think he's handling it pretty well so far, or at least he's showing us that it is. But I guarantee you that it took a lot to get there. When this was first happening, I'm sure he was struggling a lot. I feel he was. I mean, when he went to jail for 2 months, when he went to when he went to jail for 2 months, we look at it from the perspective of, that sucks for Turtleboy. You know what I mean? But when you really apply some empathy there and try to visualize, if you've never been to jail, if you've never been incarcerated in any way, shape, or form against your will, you really don't take your freedom for granted. So imagine what Aiden was going through sitting in a jail cell that entire time. The irony of that. The irony of Aiden feeling like, man, my freedom, I could just walk out of here. I could just plead guilty and just, just walk the fuck out of here. Because his freedom was already taken away. When you're in jail, you don't have any freedom. It is the epitome of your freedom being taken away. And ironically, Turtleboy sat in jail knowing that he had to in order to sufficiently fight for his freedom. And in a way, he was fighting for everyone's freedom. Because, again, if he's found guilty of this, they'll cite this. Somebody else will try to cite this case in order to take someone else's rights away, in order to take someone else's God-given freedom away. So what Turtleboy did was extremely important. That's why I say, man, all of those trolls who fucking say the things that they say about him and do the things that they're doing, like, I'm like, you people should be kissing his ass. You people should be kissing his ass. The mainstream media, they should be kissing his ass. Because he sat in jail for 2 months also for freedom of press. For their right to report on this half-assed and twist and twist it up. He sat in jail for their right to influence public opinion on this case. That's a fact. Whether you like it or not, whether you like Turtleboy or not, that's a fucking fact. That happened. You cannot change that. You cannot change that. So this dude, like, imagine the irony. So this dude is sitting there in jail this whole time knowing how important it is for him to sit there in jail and take his licking. And I think that the reason why he did it stems solely from his patriotic side. The same prosecuting agency here has already attempted to normalize such prosecutions, bringing at least 7 such witnesses. Bringing at least 7 such witness intimidation and related prosecutions for placing rubber ducks bearing political messages around Canton in connection with the Karen Reed murder case. Shout out to Rich Schiffer. I got to meet him finally. That was awesome. Undersigned counsel has defended 5 such cases, all of which were not allowed to continue for lack of probable cause. 4 did not issue from clerk's hearings. Flanagan, blah, 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 blah. And the final brought directly to arraignment was dismissed by the Stoughton court. Judge Walsh, the balance upon information and belief did not issue either. Prior to this, the Canton Police and the Norfolk District Attorney sought to prosecute the Canton 9 for demonstrating, and charges were again stopped by the court. The court found true threats, but not 3 in number as required by the statute. So basically, this is a really, really smart move by Turtleboy and his defense team here. What they're doing is citing the example that all of these other cases, the same fucking shit was applied. The same unlawful, the same unconstitutional law was applied and weaponized against these other people. And those charges are gone. That's done. That's it. It's over for them. And ironically, again, and not coincidentally, these are all people who were charged in relation to the Karen Reed case as well. So why shouldn't Turtleboy's charges be dismissed? Why shouldn't they? Like, if all of this other shit, if everybody else who was charged under the same shit for the same shit, if their charges are dropped, then why the fuck shouldn't Turtleboy's? This is just that prosecution. The related witness intimidation statute at issue here flagrantly crosses the line, criminalizing unlimited speech that subjectively causes emotional harm or economic harm to a witness or other person listed under the statute. This court should dismiss the indictments, find the statute unconstitutional as applied to this case, and limit its reach to true threats and fighting words. However, it is respectfully submitted that if the court perceives any deference to an appellate court, it should certify the question to the appeals court under Massachusetts criminal blah 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 blah, finding the issue of the statute's intrusion on fundamental rights so important or doubtful as to require a determination by a higher court. Let me see what we got here. Cherry says, I'll show you freedom of speech. Will is a bellend cuntosaurus. See, that's not illegal. You're right, Cherry. It's not. But this, seeing as this is not a democracy here on the Glarer, you just sit there for a minute and marinate on that. You're going to jail for a minute for calling me a cuntosaurus because I'm a dictator. Hell yeah. Under the Picketing statute, non-criminal speech may not be used as a basis for establishing unlawful intent to influence witnesses. Only true threats and fighting words can withstand First Amendment scrutiny. Commonwealth has abused the First Amendment through the state picketing statute by criminalizing Mr. Carney's lawful speech and assembly in a traditional public forum, completely absent of true threats and fighting words or other criminal actions. The statute provides Section 13A, however, whoever with the intent of interfering with, obstructing, or impeding the administration of justice, or with the intent of influencing any judge, juror, witness, or court officer, or anybody who looks like they're going to blow their nose in the discharge of his duty, pickets or parades in or near a building, housing court of the Commonwealth, or in a near or building or residence occupied or used by such judge, juror, witness, or court officer shall be punished by a fine of not more than $5,000 or be imprisoned for not more than a year or both. Wow. It's unreal. Every time I read that, I'm like, what the fuck? This is the most un-American shit in the world. The Commonwealth's problem here stems not from the permitted time, place, and manner restriction, but from an overreaching attempt to use non-criminal speech. I did that again. Use non-criminal speech against Mr. Carney for B, establishing an unlawful intent of interfering with, obstructing, or impeding the administration of justice, or with the intent of influencing any judge, juror, witness, or court officer in the discharge of his duty. In the First Amendment marketplace of ideas, non-criminal speech urging someone to tell the truth, come forward, etc., can certainly influence a juror or justice, etc., and may obstruct or impede a proceeding. For example, a witness asks for more time to consult counsel and recant his lies, or refuses to further cooperate after giving in to urgings, or stop lying, or admits corruption and becomes a whistleblower. Sorry, it's getting cold here. The statute's scope simply cannot be extended to non-criminal speech in a public forum without sacrificing the First Amendment. Simply put, the non-criminal speech is allowed, even permitted and encouraged to impede, obstruct, and delay anything it might be it may be virtue of its rhetorical force without risk of the utterances being declared crimes. So even encouraged, the Constitution encourages you to do this. Not only are you allowed to do it, but the mere spirit of being an American encourages you to do this, encourages you to question authority. Our entire justice system is designed to avoid a dictatorship, tyranny. That's the whole point of it. So if there's even a hint of tyranny here, not only are you, and it's not even saying it's your responsibility, it's saying not only are you protected, not only do you have the right, not only is it okay, it's encouraged. We hope that you do this. We should be encouraging each other to do these things. Which means Turtleboy, by rallying people, was exercising his First Amendment rights to its limits. But that's a good thing. One might look at it like, oh, well, he's pushing limits. How dare he? He's really dancing on the line. No, he fucking should. That's exactly what he should be doing. It's exactly what all of us should be doing. All of us.
Oh, here we go.
I think we got a super cat. Super cat. I think we got a super cat. Super cat. Super cat. Super cat. I think we got a super cat.
How dare you?
How dare you? Happy Valentine's Day, Will. Thank you, Jen Dalgos. Thank you so much. I appreciate you. Happy Valentine's Day to you too. Goes on to say, in the First Amendment marketplace of ideas, non-criminal speech urging someone to tell the truth, come forward, etc., can certainly influence a juror or justice, etc., and may obstruct, impede, or a proceeding. For example, a witness asks for more time to consult counsel and recant his. I already read this. Sorry about that. Blah, 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 blah. The Supreme Court so ruled in NAACP versus Claiborne Hardware, where they found that the picketers may be prosecuted for their conspiracy or other violation of valid laws, but it is a different matter when the state, instead of prosecuting them for such offenses, seizes upon mere participation in a peaceable assembly and a lawful public discussion as the basis for a criminal charge. Of course, the petitioners in this case did more than assemble peacefully and discuss among themselves their grievances against governmental and business policy. Other elements of the boycott, however, are involved activities ordinarily safeguarded by the First Amendment. In Thornhill versus Alabama, the court held that peaceful picketing was entitled to constitutional protection, even though in that case, the purpose of the picketing was conceitedly to advise customers and prospective customers of the relationship existing between the employer and its employees, and thereby to induce such customers not to patronize the employer. We held that a peaceful march and demonstration was protected by the rights of free speech, free assembly, and freedom to petition for a redress of grievances. The picketing statute is unconstitutional on its face and applied to Mr. Carney and must be dismissed as to each and every complaining witness under Claiborne. The grand jury presentation failed to present evidence of a conspiracy between Mr. Carney and Janelle Webb to commit witness intimidation. The Commonwealth charged Mr. Carney with conspiracy to commit witness intimidation with Janelle Webb, an Avon police dispatcher who allegedly provided license plate information to Mr. Carney, which proved that Reed murder case witness Jennifer McCabe visited the home of lead state police investigator Michael Proctor and wife Elizabeth Proctor, which flatly contradicted Proctor's claim that he did not know McCabe personally. Mr. Carney reported this bombshell development on his live show. This meeting was of such import that it became the subject of the cross-examination of Jennifer McCabe at Karen Reed's trial. There are 3 indictments alleging this conspiracy, listing Jennifer McCabe, Michael Proctor, and Elizabeth Proctor as alleged victims. There must be probable cause that the defendant joined with one or more persons to do something unlawful or use unlawful means for a lawful end, and that the defendant joined the agreement knowing that the unlawful planned and intending to help carry it out. So he didn't commit a crime. And Webb's, if I remember correctly, weren't Webb's charges dropped like pretty early on? If I remember correctly, weren't they? So if you remember, and I remember covering this, I remember going, oh shit. Because the fact is, it's not illegal to dox somebody. It's not. She was fired, yeah. But it's not illegal to dox somebody, right? Now, it might have been against Avon policy, but it's not illegal to dox somebody. And so, Turtleboy pointing out the fact that a witness in the Karen Reed case was at the home of Michael Proctor and his wife, because I remember going, wait, what the fuck? Why is there a witness at the home of the lead investigator? Since when does a lead investigator conduct interviews with witnesses at their own residence? Never heard of that in my life. There's got to be something wrong there. But it went to show that Michael Proctor lied, as it stated here, that he didn't know the McCabes. And then Jennifer McCabe sat there on the stand during this trial, and her excuse for that was that her and Elizabeth Proctor became friends and bonded over the harassment that they were enduring from Turtleboy. Get the fuck out of my face with that. Even still, if Michael Proctor was so concerned about getting a conviction because he truly believed that Karen Reed had actually killed Boston police officer John O'Keefe, he would have said, no. Don't come over here. You guys want to be friends now? That's cool, but you do it over at her house. And don't be seen. But it's a bad idea. Not, hey, you're a witness in the case that I'm the lead investigator in? Come on over. You know, you want to know how I know that was completely unethical? Because literally every other fucking thing that Michael Proctor did in this investigation was absolutely unethical. Literally everything. Mr. Carney and Webb face an indictment for a conspiracy in search of a crime. It is not a criminal offense to run a license plate. Further, there is no evidence that Ms. Webb and Mr. Carney shared the intent to intimidate any of the 3. Rather, the evidence before the grand jury demonstrates, if anything, that Webb violated a user agreement as a trained user of the system. That's what I just said. Notably, Webb has never been arraigned or in any way brought to a court for this conspiracy charge, which was handed down over a year ago. Thus, there is no other person with whom to conspire to intimidate. And no evidence Mr. Carney intended to intimidate Jennifer McCabe and the Proctors with this newsworthy and embarrassing scoop. Even if Ms. Webb had engaged in illegal content, the Supreme Court's holdings protecting journalistic publication of whistleblower information. So there you go. That's another point right there. They're citing a law and cases that dictate, that simply fucking dictate that whistleblower information is protected under the First Amendment. And if that whistleblower information includes Jennifer McCabe's fucking license plate number, then so be it, it does. It's just that simple, folks. Forrest Dump, thank you so much. New Commonwealth motion seeking sanction against defense for showing Jackson is an asshole text to Lolly. Yeah, I'm going to check that out. I mean, I don't know. After we get through this, we'll see how I feel. But I already committed. I'm already kind of regretting it, but I did commit to going over this entire motion. And so I'm going to do that. So we'll see how I feel after this. If not, then I'll just do a live and go over it tomorrow. But maybe we'll hang out a while and I'll do it. We'll see. But thank you, Forrest Dump. I appreciate it. And I may not get it because I made Cherry mad. So yeah, this is basically like he didn't commit a crime, and he didn't release the information for any other reason than to show proof and validate his own credibility as a journalist with integrity, proof of his claims that Jennifer McCabe and the Proctors have a personal relationship. The McCabes and the Proctors clearly have a personal relationship, as stated, and Michael Proctor lied about it. That's the purpose of that. That's the purpose that served, period. Not to entice anybody to commit a crime against them, but to prove that Michael Proctor lied. It's called receipts. Because that could just be anybody's Jeep. But it solidifies Turtleboy's claims that Michael Proctor knew the McCabes. And so he had every right to do that. In Bartnicki versus Vopper, in matters of public concern or importance upholding journalists' right to publish stolen or leaked information, there was a great public importance to verifying the presence of McCabe's vehicle at lead investigator Proctor's house. 1 month prior to the incident in late August 2023, District Attorney Michael Morrissey issued a video statement claiming unequivocally that Proctor did not know any of these witnesses, vouching for his impartiality in the Reed investigation. The presence of McCabe's car at the Proctor house in the evening for a social visit suggested that Proctor and McCabe collaborated their testimony. It also eviscerated D.A. Morrissey's public statement in which he vigorously defended Proctor and McCabe. Thereafter, Morrissey's own office charged Mr. Carney with a baseless charge of conspiracy in retaliation for Carney proving the corrupt relationship. For these reasons, Mr. Carney's disclosure here is completely protected by the First Amendment and its progeny. Now, I want to talk about this for a second. The way this is worded, this smells like Betero, like hot apple pie Betero. That's what this smells like. You know why? Because put it together, folks. Put it together, folks. Now, the Turtleboy and Karen Reed case that have been going like this are now officially this. Because Betterow is now on Karen Reed's defense team. Betterow is also on Turtleboy's defense team. But that's not only why. It's because now this is on record. Now the evidence that is being used in the Turtleboy case that applies to the Karen Reed case, it's a very, very easy transition from one case to the other. So now these cases are absolutely officially connected, because I truly believe that the way this was worded here was with the intent that someone, not only in Turtleboy's case and his trial, but the jury will see and hear in Karen Reed's trial. It's absolutely fantastic. Like right here, 1 month prior to the incident, blah, 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 vouching for his impartiality. The presence of McCabe's car at the Proctor house in the evening for a social visit suggested that Proctor and McCabe collaborated their testimony. You see that? Collaborated their testimony. And if this case is dismissed, folks, if this case is dismissed, this is going to be used. If that's a basis to dismiss, if that is used as a basis to dismiss Turtleboy's case, then it's going to be used as evidence towards exonerating Karen Reed. Because you have this proof. The proof that Turtleboy uncovered will prove that they collaborated their testimony. Michael Proctor and Jen McCabe. It will at least let a jury make a jury go, did they collaborate their testimony? I mean, why the fuck was she over there? Why the fuck was a witness hanging out? So you know they were talking about it. Common sense dictates that they were talking about it, which is completely unethical. So, yeah, wheels spinning. So right now, what Betterow's doing, what it looks like to me, I don't know. But what Betterow seems to be doing is merging these cases. Validating evidence in both cases. And I love it. I love it. Using each case to validate the other's evidence. Using evidence in each case to validate the other. It's brilliant. It's beautiful. This is what I said was going to happen when we first read the Letter Rose by Betterow. Remember that? When I first started reading those out loud here on this channel, I was saying it really, really looks like Betterow is using, it's genius. He's using the Turtleboy case to leverage Karen Reed in her case. And it's fantastic. And it's completely legit. It can all be proven. It can all be proven. For these reasons, and look, and the way it goes on, Michael Morrissey, he's calling out Morrissey himself. So here, they could even call Michael Morrissey to the stand. Karen Reed's defense can call Michael Morrissey to the stand. Turtleboy's defense can call Michael Morrissey to the stand, because here we have, right here, Michael Morrissey flat out stated in this public video statement that there was no connection, no personal connection between the McCabes and the Proctors, whereas Turtleboy proves it. Fascinating. So right here, this leaves Michael Morrissey open to being subpoenaed and put on the stand by the defense in either case. Either fucking case. Thereafter, Morrissey's own office charged Mr. Carney with a baseless charge of conspiracy and retaliation for Carney proving the corrupt relationship. And again, if there wasn't even, and that's that right there, they're going to talk about that too. They didn't really emphasize on it, but they emphasized on it just enough. Whereas this Webb person, even though he was charged in conspiracy, she was charged, but she was never even arraigned. Nothing happened. They only dropped her name in order to somehow validate the conspiracy charge against Turtleboy. But the thing is how can there be a conspiracy charge if the person that he conspired with has no charges? Wasn't even arraigned. It's been a year. Fascinating, right? So that begs the question. It begs the question. How can you charge Turtleboy with conspiracy when there's no co-conspirator? And it's fun because it's fun because it says something. It speaks to the argument. It helps solidify the argument that Turtleboy is being targeted. He's being targeted. He's being railroaded because he's being targeted by the Norfolk County DA's office. It shows they're only interested in getting him convicted. If there's a conspiracy charge here, why did they seem to show absolutely no interest in pursuing against Webb? If nothing even happened, think about that. She was never even arraigned. I'm here talking about how she had her charges dropped, but she was never even arraigned. It's been a year. Nothing has happened. It's just there. So if I'm a juror and Bradle or Betterow present to me that there's this conspiracy charge and the other co-conspirator was charged but never even arraigned, and it's been a year, and I'm also trying to, and these people are trying to convince me, the juror, that they're targeting Aiden Carney, then I'm going to go, yeah, that's a pretty fucking good indication of him being targeted. This is just crazy. The more I read this is stuff we were already aware of. For these reasons, Mr. Carney's disclosure here is completely protected by the First Amendment and his progeny. The prosecutor impaired the integrity of the grand jury by misrepresenting fact and law, soliciting opinion, and distorting the state of the evidence by selective omissions, and the indictments must be dismissed. We're seeing that a lot, right? A lot of selective omissions, right? Give me just 1 second here, folks. I got to step away from just a second. Just a second. Oh, okay. Thank you guys. Sorry about that. All right. So this is saying prosecutors are not required in every instance to reveal all exculpatory evidence to a grand jury. However, the integrity of the grand jury proceedings has been impaired and dismissal is warranted where the omitted exculpatory evidence would likely have affected the grand jury's decision to indict. See, I could see a judge having trouble with this, in theory, because if they're not required to include exculpatory evidence, then how can they really argue that the evidence that was omitted that is exculpatory, since they're not even required to, would have swayed the jury's decision? So, I mean, if the prosecution can just keep shit out in order to get their indictment, then, but I'm confused. Are they saying that they can do that or they can't do that? You know what I mean? That's where I'm confused. Can they do it or can't they do it? You know? That's where I'm confused. If the grand jury were not made aware of circumstances which undermine the credibility of evidence that is likely to have affected their decision to indict, then the appropriate remedy may be dismissal of the indictment. Hold on, let me read that again, because I think that might have just explained what. If the grand jury were not made aware of circumstances which undermine the credibility of evidence that is likely to have affected their decision to indict, then the appropriate remedy may be dismissal. So they're saying that if that exculpatory evidence would have affected their decision to indict, then they would have had the obligation to share this with the grand jury, this evidence with the grand jury. Yeah, sorry, man. Yeah, I got that I got that Ethernet cable, and I just haven't installed it yet because I got to run it like along a wall and up 2 flights of stairs, and yeah, it's just a pain in the ass. That's why I haven't gotten to that yet. Yeah, if there's information, this is basically what I'm getting out of this, is that if there's information that would affect the credibility of the evidence that they're presenting to the grand jury, then they misled the grand jury, and therefore there should be a dismissal. That's what I'm getting out of that. So it's definitely a misrepresentation of the truth. So if there is information that fucks up the credibility or could potentially fuck up the credibility of the evidence that they're trying to use to convince the grand jury of the charges against Aiden being valid, then it's unethical to not share this. It means that it means that they're presenting evidence that is not valid or could not be valid or could be deemed invalid. And that is misleading the grand jury. So now I understand. I get it. Let's see. The withholding of a portion of the defendant's statement distorted the portion that was repeated to the grand jury in a way that so seriously tainted the presentation to that body that the indictment should not have been allowed to stand. The prosecutor's repeated selective omissions here qualify as grounds for dismissal, as set forth below. Odell and his progeny require dismissal of the indictments due to the prosecution's impairment of the integrity of the grand jury proceeding. The transcript reveals the prosecutor's repeated and improper references to the conduct of others as a basis for wrongdoing by Mr. Carney. For example, at transcript dated December 5th, blah, 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 Jennifer McCabe sweepingly asserts without evidence and speculates that Mr. Carney is responsible for the alleged actions of others. He brings people with him. She's being quoted here. He brings people with him. They take pictures, they stop, and they yell and take video. They send it to him. It's almost like they get rewarded. There is no basis for joint venture liability addressed anywhere in the grand jury, yet the prosecutor repeatedly includes other group behavior suggestive of guilt without evidence linking the behavior to Mr. Carney. McCabe refers to actions of followers of Mr. Carney. I don't know if one of his followers is going to show up. They text me, they email me. They are repeated references throughout the testimony, implicitly assigning blame to Mr. Carney for behavior of alleged followers. At page 35 of the same volume, McCabe alleged without curative instruction that followers of Mr. Carney emailed her that she would be raped her on her lawn and sent her sexual messages about her daughter. As deplorable as that conduct would be if true, the prosecutor should not have allowed that prejudicial evidence to be offered against Mr. Carney by allowing such prejudicial and inadmissible evidence to be received against him. The prosecutor impaired the integrity of the grand jury because such prejudicial evidence may have resulted in Mr. Carney being indicted for the alleged action of others. Now, that's fucking, yeah. Think about that. So here, they're stating that exactly what we predicted. Exactly what I predicted at the beginning of this thing is Jennifer McCabe, or not that it's not that I'm predicting. I needed to be reminded here that this already happened. Jennifer McCabe is already blaming Turtleboy's followers, and the prosecution is trying to use that. And Turtleboy cannot be held accountable for other people's actions. They're all adults. Turtleboy cannot be held accountable for other people's actions, period. And in Jen McCabe's own words, her accusations in open court were towards other people, but not him. Think about that. Elizabeth Proctor did the same. She refers to Mr. Carney's followers sending her emails and targeting her children without a curative instruction. Michael Proctor complains that protesters parked on his lawn and spit at his house while driving without any proof that Mr. Carney directed such actions. At the last session on December 20th, 2023, the prosecutor instructed the grand jury on the witness intimidation charge without addressing the First Amendment limitations on the alleged speech at issue. The prosecutor failed to instruct the grand jury on the limits related to any alleged harassment that served as the basis of the allegations. The prosecutor failed to address the First Amendment protections, which protect speech constituting political hyperbole. He did not instruct the grand jury on issues related to incitement to imminent lawless action, opinion satire, and the necessity to find true threats or fighting words wherever First Amendment speech is concerned. Instead, the prosecutor repeatedly mischaracterized Mr. Carney's speech as actions or conduct. That's great. Yes, that's a great point. Actions or conduct. when it's really just his speech. There are no actions or conduct applied here. It's just his speech. You can't call those actions and conduct. It's just him saying words does not fall under that category. The omissions created a foregone conclusion of indictment and deprived Mr. Carney of the right to have the grand jury consider the proper treatment of speech and First Amendment limitations on the prosecution. The prosecutor also impaired the integrity of the grand jury proceeding by eliciting improper opinion and hearsay. For example, the prosecutor impermissibly expressed his personal opinion that Julie Nagel was a victim. See December 29th, blah, 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 blah. At the end of her testimony, she is questioned about Mr. Carney's online reporting in which he simply exhorted Nagel to tell the truth without making any threats or ensuing fighting words. Rather than present evidence of Mr. Carney's actual intent, the prosecutor improperly asked Nagel her opinion of Mr. Carney's intent. In your opinion, is he trying to get you to change your testimony? Answer: yes, correct. Wow. If that's not leading, I don't know what is. Suggesting wrongly that the context supports a witness intimidation charge. Wow. Yeah. I mean, we're talking about Ken fucking Mello here, dude. With respect to Elizabeth Proctor, the prosecutor asked Detective Tully his opinion of Mr. Carney. Oh, that got skipped there. Or maybe not. I don't know. Maybe that's not in order. Let me check. I think that's, yeah, we're good. With respect to Elizabeth Proctor, the prosecutor asked Detective Tully his opinion of Mr. Carney's intent, any other incidents that you feel were intimidating to Elizabeth Proctor. And the detective answers without reference to any evidence from Elizabeth Proctor on the point that Mr. Carney was protesting to the neighborhood, giving the reader no idea whether she was intimidated by it or whether the alleged fear experienced was within O'Brien versus Borowski super or protected speech. The repeated reliance on opinion is again a directive from the prosecution to indict and warrants dismissal. The repeated use of multiple police officers and civilians to express their inadmissible opinion of Mr. Carney's intent may have affected the proceeding by leading the grand jurors to credit inadmissible opinion evidence on Mr. Carney's intent as a basis to believe that every witness shared that view of Mr. Carney's intent. Finally, improper opinion and hearsay testimony was used to falsely establish a conspiracy between Mr. Carney and Avon Police Dispatcher Janelle Webb. The prosecution failed to present any evidence that Ms. Webb and Mr. Carney conspired to engage in criminal conduct. Accessing the license plates was not a crime, and in any event, there was no evidence before the grand jury that Webb obtained the information with the joint intent to commit witness intimidation. Instead of seeking to introduce admissible evidence in support of this allegation, the prosecutor asked Trooper Fanning, is it fair to say that, in your opinion, that she conspired with Mr. Carney to disclose the information in these queries and to have them published online? Mr. Fanning answered, absolutely. These errors combined with the prosecution's erroneous instructions to the grand jury impaired the integrity of the grand jury proceeding and renders the indictments defective. Wow. Let's see something here. Yeah, this is just fucking crazy, dude. All right. I want to just get through this because there's other stuff I want to talk about here. Taken in turn, the viewed in light of the legal principles set forth above, each alleged victim's testimony fails to establish probable cause for witness intimidation. Picketing with unlawful intent and conspiracy, and the indictments must be dismissed. In their vendetta against Mr. Carney, the dual Carney-Karen Reed investigators were clouded by conflict of interest and desperate self-protection. To shut down Mr. Carney, they invented a new crime, witness intimidation by journalism, invented unlawful intent to influence from peaceful protected speech to prop up picketing charges, and speculated that Ms. Webb conspired to intimidate when she was simply a whistleblower and Mr. Carney was a journalist protected by the First Amendment, publishing newsworthy information. Each of these unprecedented attempts to saddle Mr. Carney with criminal behavior was an unmitigated failure. Each alleged victim will be referenced in turn as follows. Yeah, so I love this because there are these little slip-ins that I love ever since Mark Betterow joined Turtleboy's team. I always suspected that what he was going to do was now this is what I'm saying is, and this is why it's also beautiful now that Betterow is on Karen Reed's team as well, because Turtleboy set out to prove that the investigators involved in her case were corrupt and operated and engaged in procedures that lacked integrity, to say the least. Now, this is going to be presented in Karen Reed's trial, I'm sure. Because ironically, as I've stated many times, ironically, Turtleboy, Betterow, Bradle, they wouldn't have the proof that Karen Reed, that the investigators in the Karen Reed case were corrupt until they charged him. And now they have proof. So Karen Reed's camp is going to be able to cite Turtleboy's case like beautifully. They're going to be able to cite Turtleboy's case in the Karen Reed case, proving that those very same investigators are not credible. Any of the investigators that were involved in Turtleboy's case, once they're able to prove that there was collusion taking place, now they're going to be able to convince the Karen Reed jury that those officers are not credible any more than Michael Proctor is. And the irony of that is Turtleboy wouldn't have this proof unless they violated his First Amendment rights. Amazing. I mean, if that's not ironic, I don't even know what is. The irony of that is just beautiful. I love irony sometimes. I'm a big fan of it. And Turtleboy would not have the proof that the law enforcement agents involved in her case were corrupt until they charged him, because the very same corruption was applied to charge him. So taking that proof and presenting it in the Karen Reed case discredits those investigators, and it helps Karen Reed's case. This is just a work of art. The evidence relating to Trooper Proctor was that Mr. Carney called a phone number which was made publicly available in the Reed court filings, meaning that Turtleboy didn't dox the phone number. It was out there. The same methods in which Turtleboy was able to obtain that phone number, anybody could have applied those same methods and gotten them too. And again, it's not illegal to dox somebody. So even though it sucks sometimes, but it's not illegal to dox somebody. Even though it sucks, it's not cool. I'm fully against it. It's not illegal. And the fact is that the very same methods that Turtleboy applied to obtain Michael Proctor's number could have been obtained by anybody watching that live stream where he called Michael Proctor's phone. Mr. Carney was calling numbers from witness Jennifer McCabe's publicly filed call log and was shocked, exclaiming, "Oh my God, it's Proctor." Mr. Carner was investigating who Ms. McCabe was calling. See message aired in real time, blah, blah, blah. On Mr. Carney's live show, offered as a video, thumb drive and read to grand jury at blah, 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 blah. Mr. Carney left a message seeking to ask him questions that were of public concern, stated matters of his opinion of the Reed case, employed satire, and political hyperbole. Hyperbole, I believe. Hyperbole. I'm glad I finally figured that word out. Hyperbole. You know, I count on you guys sometimes to help me out, and you guys never do. Like, I'm really sick of that shit. Like, I sit here and I'm trying to pronounce this word forever, and I'm counting on you guys to help me with it, and you just leave me hanging out there. Leave me hanging out there like a Seinfeld matzo ball, and it sucks, man. I'm counting on you guys, bro. It's not cool at all. I had to figure out that word all on my own, hyperbole, without any of your help. Because Mr. Carney was sharing the public court documents on his screen to analyze it for journalistic purposes, Trooper Proctor's number was seen by the audience. There was never any felonious witness intimidation, felonious witness intimidation, only a time-honored exercise in smart investigative journalism, connecting the dots and following the evidence between witnesses calling each other in the Reed case. The fact that the number already published in a court filing was released does not criminalize the action, nor does the alleged calls from the third parties to Proctor's number, allegedly causing Proctor to have to get a new number. Now, yeah, like, think about that. Let's just look at it from a simple perspective. Let's just dumb this down into its most simple form. Okay? An example as to why that was not illegal is freedom of the press. Because think about it. What's the difference? Where is there a law that says that I could not explore this case live? Where is there a law that says that I must obtain my information in covering this case in private? Because if you remember, I've talked about this case. I explored this case live. I could have come across anything. Now, I choose to make the personal effort to try to exclude people's phone numbers and personal information, last names. I don't like to show kids on here, even though it's not illegal for me to do that. These are just the practices that I prefer to engage in for my own peace of mind. Even though on most of this stuff, it's nothing to even worry about. It's just the extra steps that I tend to take in the way that I conduct my channel. That's it. But Turtleboy is absolutely within his rights to conduct his methods, to apply his methods of investigation, whether they be behind the scenes or live. It is his choice. There is no law that says that he has to conduct his investigations in private. He can absolutely live stream every single lead, he can live stream when he receives a lead if he wants to. And then explore it, live streaming, without having to edit anything. Who gets to dictate the method in which the methodology in which Turtleboy applies to exercise his freedom of the press? Who?
Oh, here we go.
I think we got a super cat. Super cat. I think we got a super cat. Super cat. Super cat. Super cat. I think we got a super cat.
How dare
La La Land. Don't count with me helping with hard words. Based on this, I won't. And of course, it's Crazy Brazilian Lady. Thank you, Crazy Brazilian Lady. Yeah, dude. Like, dude can fucking he can conduct his investigative journalism methodology. He can apply his investigative journalism methodology in private, in public, however the fuck he feels like it. And if he happens to come across a number that's already public, okay, well then it fucking happens. Now you can form a personal opinion about him if you want. You're entitled to that, but you don't get to say that what he did was illegal. He didn't break any law. There is no evidence whatsoever of any intent to cause physical injury or property damage to Proctor within the O'Brien versus Borowski limitations, or emotional or economic injury, which is unconstitutional for that matter. The speech is protected by the First Amendment. Proctor also testified about the July 2023 rolling rally protest in Canton. He was not home, but he testified that he observed. Hold on, what does this footnote say? Oh, I love this. If this is a crime, the prosecutor is guilty of the same. After the indictments of the Superior Court arraignment, the Commonwealth prosecutor Mello published the cell phone numbers of Attorney Bradle and two paralegals assisting Mr. Carney on the front page of the public court filing. I remember this. Causing the paralegals to receive vulgar and alarming text messages, and Attorney Bradle had to have his email account hacked and password altered after the number was used as a security entry the same evening of Mello's publication. The defendant's motion for sanctions and disqualification remains pending and on the docket. So right there, I love that. In that footnote, they squeeze that in there, that little tidbit of fact in there that I absolutely remember happening. I remember streaming the hearing myself, where Ken Mello was trying to was trying to deprive Turtleboy of his attorney-client privilege. It was amazing. I couldn't even believe that shit. I couldn't even believe that shit. And so sure enough, they snuck that in. I love that in the footnote. Like, it should be noted that they're trying to say that Turtleboy harassed Michael Proctor by releasing his phone number, but Ken Mello did this to Turtleboy's attorneys. This is a fact that happened. I remember it. He did it in a very public court filing. Proctor also testified about the July 2023 rolling rally protest in Canton. He was not home, but he testified that he observed that the MSP video recorded the rally and he viewed the footage. He noted no damage to anyone's property, no testimony about any charges arising from the video recording, and a complete absence of actionable criminal behavior from demonstrators peacefully exhorting witnesses to tell the truth. Mr. Carney was the only person charged arising from the rally. The prosecutor, right, exactly. So why was he the only one charged? Again, another piece of evidence that proves that Turtleboy was targeted by the by the Commonwealth of by the Norfolk County DA's office. Prosecutor craftily sought to implicitly Jesus fucking Christ. Prosecutor craftily sought to implicitly assign blame to Mr. Carney for vague alleged criminal conduct of third parties. Got over that hill. Allegedly spitting out their window and parking in his lawn or on his lawn. It is notable that no such video was introduced in the presentation and none is known to exist from discovery. Mr. Carney digitally recorded the rally and provides a clip from the rally where he warns about a no trespassing sign and turtle crossing sign on Proctor's lawn. Proctor lied about criminal behavior and also admitted he didn't even know what Mr. Carney was saying at the rally and that he didn't know Mr. Carney's motivations or intentions. Finally, Mr. Carney has reviewed the Canton police call logs from July 22nd, 2023 and found not a single call to police to report anyone involved in the rally. There is no rational proof of any unlawful intent to influence testimony as required by the picketing statute, only lawful First Amendment protected non-criminal speech. Blank also revealed the improper motives for effecting Mr. Carney's arrest in text messages provided in discovery in a September 3rd, 2023 group message in discovery. I'm not sure what that's referring to, but admits to having his motivation for having Mr. Carney arrested and is employing political hyperbole and no thanks to you guys, and satire under the First Amendment, writing about blah 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 and intimidating him or trying to obstruct justice as a false pretext used to silence him. So what I think they're talking about Paul O'Keefe here. Thereafter, in a July 13th, 2023 email, calls Mr. Carney, called him and asked, again, showing the motivation for arresting Mr. Carney wasn't for intimidation, but for personal revenge because he didn't like the First Amendment protected public references he was making about him. Elizabeth Proctor, wife of lead investigator Proctor. Mrs. Proctor is the wife of Trooper Proctor. His testimony epitomizes the defective nature of the presentation by the prosecutor. Her transcript is replete with complaints about the actions of others. Aside from the defendant, within the implicit suggestion, Mr. Carney is legally responsible for the complained on behavior or speech, which disingenuous suggestions about Mr. Carney's intentions when he is clearly engaging in online political hyperbole, satire, or opinion with baseless and conclusory claims that the defendant is threatening, and again with improper opinion. Mrs. Proctor admitted calling an online commentator's workplace trying to get them fired for speaking about her husband. In the grand jury transcript dated December 14th, 2023, she admits, I acted out and targeted one of Mr. Carney's followers who was coming at me and called the employer of them. This footnote says, in January 2025, Trooper Proctor was the subject of a state police review board inquiry facing possible termination for misconduct in the Karen Reed investigation. The decision is pending as of the date of this motion. He was put on unpaid leave for months prior to the hearing. We already knew that. And it was obviously not the right thing to do, she said. Elizabeth Proctor here about calling people's jobs. I mean, what the fuck? Mr. Carney was investigating a matter of public concern. The wife of the lead investigator in the Karen Reed case was trying to punish people exercising their First Amendment rights, commenting online about her husband's alleged corruption by getting them fired and or bullying them at work. In Mrs. Proctor's world, She may seek to inflict economic harm on whomever she wishes, but Mr. Carney must endure a felony prosecution because he is investigating corruption in matters of public concern. In the grand jury, Mrs. Proctor continued her ill-advised campaign to punish her enemies by lying about Mr. Carney. She stated Mr. Carney has been threatening, and she reports to pulling emotional strings by referencing her children. The reality, as shown in the video proffered by the Commonwealth in support, shows that Mr. Carney expresses only his protected opinion about Proctor's actions and clearly employs protected political hyperbole. Why am I having trouble with it again? Hyperbole and satire to underscore the seriousness of police corruption by claiming absurdly he is going to take custody of their children when Trooper Proctor goes to jail for his misconduct. This is fucking hilarious. Obviously, in no rational world is this a true threat or fighting words uttered across cyberspace. Yet, with a straight face, the prosecution and the witness seek to sell the grand jury on the notion that Mr. Carney threatened to harm my children, to take my children. Just like in Watts the context inherent absurdly of the claim, as well as the political and public concern on the content, all conclusively contribute to the conclusion that the speech is protected. O'Brien, blah, 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 also thwarts any prosecution here where her fear is not of a crime being perpetrated, but again, absurdly fear that Mr. Carney would engage in child custody proceeding and have custody of her kids while her husband does hard time. The one Elizabeth Proctor indictment here for witness intimidation must be dismissed. So they're going down the list. I love this shit because they're going down the list of each indictment, each witness who claims they're being harassed and intimidated. Each witness. I love this shit. Angie's Wave, thank you so much. Cash for more wine nights. Cash for more wine nights when traveling to Airbnbs with forked up cabinet pools. Thank you so much. I appreciate it. Oh man. Yeah, I appreciate you guys. You guys are amazing. Jennifer McCabe and Matthew McCabe. This should be fun. This should be fun. Ms. McCabe is a Karen Reed case witness who Google searched on her phone how long to die in cold, which is a fact, people. The only dispute is whether or not she did it at 2:27 a.m. Out of the more than 4,500 searches she conducted on her phone, a defense expert found that this search was the only one ever deleted in the life of the phone. In the life of the phone. A hotly contested issue in the Reed prosecution involving a battle of experts involves the time of the search. Now, the way this is worded right here, this is the first time I've used that I recall those words, in the life of the phone. That's a big deal because it also puts into perspective those 4,500 searches, every single search, literally every single search that she's ever made on that phone. From the moment of that phone's conception and use of the first use of it to its no longer existing. That was the only search that was ever deleted. Ever deleted. Not the same night, not the same month, not in a condensed period of time, just in the entire phone's history of its entire life. Only that search was deleted, which highly indicates that there's suspicion in that deletion. it highly indicates that Jennifer McCabe was never in the habit, even remotely, of ever deleting searches. But it happened. Piney Woods Law and Crime, thank you so much. Hey, Will, the Commonwealth's findings today are docket number, blah, blah, blah. I can't figure out how to pull those docs, but one is a motion for sanctions. Outrageous. Yeah. Let me see something real quick. Okay. Yeah, Cherry's having the same trouble. She sent me a message saying, I'm seeing that they dropped filings, but I'm not seeing them yet. Probably Monday. So yeah, there's a thing here showing that they're just not available yet to go over. But they were filed. Thank you, Piney Woods. A hotly contested issue in the Reed prosecution involving a battle of experts involves the time of the search. If she performed the search at the timestamp 2:27 a.m., as is claimed by the defense, this would constitute powerful evidence of her involvement in a cover-up of the murder of John O'Keefe. The prosecution claims she entered the search after 6 a.m. at Ms. Reed's behest when Mr. O'Keefe was discovered near death in Brian Albert's front yard. Mr. Carney strongly supports the defense position of 2:27 a.m. and has extensively written and reported of this issue and made t-shirts. It doesn't say that there, though. Trooper Tully encapsulates Mr. Carney's interactions with Ms. McCabe of the transcript. Ms. McCabe spoke out over Mr. Carney's investigation of her, texting the district attorney and the prosecutors demanding action. She also sought a Stoughton District Court criminal harassment order against Mr. Carney, but was rebuffed. Walsh denying her order under First Amendment grounds. So Judge Walsh was like, nah, dude, he's protected under the First Amendment. Get the fuck out of my courtroom. No. And then happened again. At the hearing, McCabe showed that the case was not about witness intimidation, but about her silencing Mr. Carney's reporting about her involvement in the murder of John O'Keefe. I love this. I love the way this is. This is not even pulling punches here. Clip of McCabe asking Judge O'Malley, is there anything you could do to get him to stop blogging about me? Wow. And the judge demurring and declining to issue order of First Amendment grounds. Significantly, the prosecutor did not disclose this adverse decision to the grand jury, depriving them of the information that the conduct was already adjudicated to be protected speech. Finally, it is important for the court to consider that the fact that McCabe has been protected and not charged in the case does not criminalize Mr. Carney's reporting on her involvement. Reporters often are ahead of the story, anticipating that law enforcement will actually follow the evidence where it leads and act accordingly. Once again, the prosecution fails in establishing any criminal behavior on the part of Mr. Carney. The evidence adduced, I guess, shows only dogged investigative journalism with impolite or distasteful and perhaps juvenile invectives, but also involves matters of extreme public concern focused on the cover-up of the murder and potential complicity, or at least shocking incompetence of the state police. It is not unique or uncommon for a journalist to follow or confront a subject in public, or to go to their door and ring the bell seeking answers to important questions. It is certainly not criminal on its face, and especially not when viewed through a First Amendment lens. Well said. Yet all of these words and instances are repeatedly used in the prosecutor's presentation and implicitly offered as grist for the indictment mill. Here, Once again, Mr. Carney never used threats or fighting words, was asking questions about her extremely suspicious behavior and expressing his protected opinions on this case and the culpability of various actors. Hurt feelings are legally immaterial, and using them for an indictment is unconstitutional. All of this is First Amendment protected and set forth, and no state statute can criminalize such speech beyond these protections. The actors may civilly sue for libel, defamation, and the like, subject to truth, First Amendment, and opinion defenses, but the realm of criminal prosecution is unavailable for non-criminal speech. Reporters address suspects and witnesses all the time, demanding, shouting, and repeatedly pressing requests for answers and whether they are guilty. Mr. Carney did nothing above and beyond such speech. Now, think about it. Let me offer this other perspective real quick. You have Aiden Carney, aka Turtleboy. Let's just say he's yelling and screaming, right? Putting a phone in Jennifer McCabe's face, and he's going, "What are you going to do when you go to prison? What are you going to do when you go to prison? What are your kids going to do when you go to prison for for your part in the death of Boston police officer John O'Keefe and the cover-up? What are you going to do?" Right? Now, then you have some random paparazzi, right? Some rando paparazzi who gets in the face of, say, Alec Baldwin. And that paparazzi is going, "Alec Baldwin," depending on their political beliefs and their stance on the Second Amendment, they want to go, "Alec Baldwin, what are you going to do when you go to prison for shooting a gun irresponsibly? What are you going to do? What are you going to do? What are your kids going to do when you go to prison for not applying trigger discipline when you're on the set of a movie? When you go to prison for this?" Now, should that paparazzi be arrested? Why weren't any paparazzi arrested? Why aren't any paparazzi ever arrested when they shove their phones into somebody's face who's a celebrity and asks them questions? Even hard questions, even questions that they might find offensive. I'll tell you what the difference is. Literally the only difference is that Jennifer McCabe is suspect in the court of public opinion for having something to do with John O'Keefe's death. That's it. That's literally the only difference. So you can't, like, there's no difference. There's no difference. If somebody shoves a phone or a camera in fucking Jared Leto's face, there's no difference. If somebody shoves a camera or a phone in Diddy's face, accusing him of being a rapist and a sadist, that journalist is still entitled to their own opinion. I didn't mean to put Jared Leto in the same category as P. Diddy. I was the first celebrity that came to my mind. So, I mean, yeah, there's no difference. The only difference here is that there's an interest in the local government. The local government there has an interest in Karen Reed being convicted. That's the only difference. Certain parties within the local government have a personal interest in Karen Reed being found guilty of this crime. McCabe claimed to the grand jury she made Mr. Carney aware she wanted him to stop questioning her without any supporting details. Mr. Carney denies any such communications. McCabe is on video where she is questioned at the I don't know how to say that, lacrosse game, laughing and treating, we all know about this, treating the episode like a joke, and never tells Mr. Carney not to question her. Not one time did she even say anything that I recall addressing him directly. I remember her husband getting in his face and saying, "What are you doing here? What do you want? What are you doing here?" I remember somebody else going, "Excuse me, do you have a child on the field?" I remember that. Some Karen going, "Excuse me, we don't do that. Do you have a child on the field? If you don't have a child on the field, can you please leave?" I remember some Karen doing that shit. But I don't remember Jennifer McCabe addressing Turtleboy directly at all. Much less saying, "Hey, can you stop asking me questions?" That shit didn't happen. In fact, McCabe shows she is not afraid or intimidated by Mr. Carney, who she repeatedly taunts online. On May 10th, 2023, McCabe reached out to Mr. Carney, sending him a bizarre, half-naked photo saying, "Haha, it's your boy John C." 20 days later, McCabe went to the Stoughton court on May 30th, 2023, seeking the restraining order. McCabe unsuccessfully claimed she is in fear under the statute, and then only days after, on July 1st, 2023, she again engages with Mr. Carney online saying, "Sorry to bother you, have fun in Mashpee," indicating she apparently knew his whereabouts. There is clearly no intimidation or emotional distress afflicting Mrs. McCabe, who initiates and enjoys wrangling online with Mr. Carney. That's proof right there. Like, if she's so intimidated and she's so traumatized by Aiden Carney, the infamous Turtleboy, if she's so intimidated, why the fuck is she texting him? Why the fuck is she texting him going, "Hey, have fun at blah, 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 blah," implying, "I know where you are. I know where you're going to be." Why is she doing that if she's so fucking scared? McCabe, like the state police and the prosecution, only want to use the system to silence him and will say anything to get her way. Also enjoys unprecedented access to the blah, blah, blah himself. She has direct access to the blank. Cell phone is shown in her impounded text message complaining that so blah, blah, blah. I don't even know what this is. Mrs. McCabe's wishes are clearly a motivating factor in the improper effort to silence Mr. Carney through these unlawful indictments. In any event, a reporter pursuing witnesses or on matters of public concern is entitled to keep trying as long as he engages in lawful conduct, and his non-criminal efforts to do so are protected under the First Amendment. At the rolling rally, McCabe admitted she did not call the police and suffered no damage or criminal conduct against her. So why was the rolling rally used as evidence to indict him? Where Mr. Carney engaged in non-criminal speech and was covering matters of public concern, there can be no witness intimidation or unlawful intent. Jennifer McCabe's husband, Matthew McCabe, is also a supposed victim of witness intimidation and picketing with unlawful intent from the same encounter with Ms. McCabe and from the July rolling rally. A view of the confrontation at the lacrosse game cited by the prosecution and introduced within Exhibit 1 shows no threats of fighting words uttered by Mr. Carney, but rather shows that Mr. McCabe approached and confronted Mr. Carney, and that he certainly was not intimidated by him. And I should point out, just a quick example of what fighting words are is just a quick example that comes to mind is Chris Albert approaching Turtleboy and saying, I could take your face and drag it all up and down the sidewalk. Right? Them is fighting words. So why wasn't Chris Albert charged for witness intimidation? Is Turtleboy not a witness in his own case? Isn't he a potential witness, if not already a witness in his own case? Isn't he a potential witness? Doesn't the law, chapter 28, 13A, 13B, cite that a potential witness, it protects a potential witness against this shit? So why wasn't Chris Albert charged with intimidation, witness intimidation, under the same law? And there's video footage of him doing it. Approached Mr. Carney and that he was certainly not intimidated by him, meaning Matt McCabe. Rather, the video, Exhibit 1, McCabe M folder, clearly shows that Mr. McCabe is not intimidated in the least and that he is the aggressor, that he bumps Mr. Carney, who is trying to ask a question, and that he greets Carney by saying, "How's it going, tough guy? I didn't realize how small you were." On the issue of intent and motive on the part of Mr. Carney, Mr. McCabe testified that I don't know what the point was about Mr. Carney's investigative efforts at the lacrosse game and outside court. The prosecutor asked him, "Do you have any sense as to why Mr. Carney is doing this?" And Mr. McCabe stated that the reasons are building his profile, building his following, and working as a mouthpiece for the defense to taint the jury pool. Wow. McCabe doesn't mention anything about the defendant trying to influence his testimony. Excellent point. Even when he is led and coached by the prosecutor asking, what is his purpose directly with you? And, he says, we're the witnesses, but doesn't mention any perception of influence in the testimony. Once again, it is clear that with respect that Mr. McCabe, Mr. Carney uttered no criminal speech and is as protected against the husband as he is against the wife. Regarding picketing with unlawful intent for Mr. Carney, with Mr. Carney's presence in the McCabe neighborhood at the July Rolling Rally, the allegations surrounding that episode are equally unavailing. Mr. Carney uttered only non-criminal speech, opinion satire, political hyperbole. I did it again. There is no criminal intent that can be found from lawful, non-threatening speech, and any contrary interpretation of that state picketing with unlawful intent statute violations, the First Amendment, and the case law comprehensively set forth above. Now we get into the Colin Albert stuff. Colin Albert is the nephew of Brian Albert, the homeowner of 34 Fairview Road in Canton, where the body of John O'Keefe was found. Reed's defense has posited that Colin may have been complicit in O'Keefe's death. Colin Albert was present at the Brian Albert home, but claims that he left shortly before Mr. O'Keefe and Miss Reed arrived. See generally December 5th, 2023, grand jury task, blah, 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 blah. Detective Brian Tully. Mr. Carney has written and reported extensively on Colin Albert and advocates in his reporting that he was present in the home during the assault and cannot prove otherwise. In the grand jury, Colin Albert testifies to alleged emotional harm, quitting the Bridgewater State football team in the circumstances because he does not wish to be a distraction, and alleges that Mr. Carney calls him a meathead, jock, and a bully. I mean, dude. Yeah, man. If the football helmet that you chose not to wear anymore fits, wear it. Albert is asked by the prosecutor, why do you think Carney is doing this? And Albert responds that he doesn't know, indicating that he doesn't think that it is to intimidate him as a witness. So he's like, I don't know. Duh. I don't know. So basically, they're opening these doors for these witnesses, and they're like failing. Let's see what this footnote says. State police and Norfolk DA have recently sought to prosecute the defendants for felony witness intimidation for leaving spot. Oh, okay, we already read all this stuff. But let's get to this. Mr. Carney references to the Advantage Boys and Bang Bang statements on the Colin Albert voicemail and YouTube show are impressions of those same statements by Colin Albert from an intimidating online video made by him where he physically threatens rival teenagers called the Advantage Boys. Mr. Carney satirized the statements on the message back to Colin Albert. As such, it is misleading and distorts the grand jury evidence for the Commonwealth to omit the original statements by Colin Albert and risks creating the impression that Mr. Carney making these statements constitutes his own threats or fighting words. The original Colin Albert online video is offered as a defense exhibit filed separately in further support of the Odell dismissal request. So Albert responds that he doesn't know, indicating that he does not think that it is to intimidate him. All of Mr. Carney's videos offered at the grand jury within Commonwealth Exhibit 1, as well as his interactions in public commentary, are protected in speech in the First Amendment and cannot support the one charge, blah, 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 blah. As stated, respecting the other alleged victims herein, causing emotional harm to the psyche of Mr. Albert is not criminally actionable if the alleged means is not criminal speech. I'm going to cut that short and just say Colin Albert's feelings being hurt is still protected, still protects. Just because Aiden Carney's words hurt his feelings, they're still protected under the First Amendment. And here, Brian Albert is the homeowner of 34 Fairview in Canton, Massachusetts, where Mr. O'Keefe was found deceased because he was the descendant on the front lawn. The Reed defense team contends Mr. Albert was complicit in the assault of Mr. O'Keefe and the subsequent cover-up. They further contend that the investigation was severely compromised due to his status as a retired police officer. The defense also notes a litany of suspicious behavior on the part of Brian Albert, such as tearing up the floor of the basement, getting rid of the family dog, and the defense expert finds to have bit Mr. O'Keefe, selling the home, not leaving the house to investigate the dead body on his lawn, which was so advised, and alleged inconsistent or incredible statements. Brian Albert is the alleged victim of one charge of picketing with unlawful intent. Albert made several generalized characterizations of behavior from the rolling rally, claiming that Mr. Carney was attempting to intimidate me and saying things of a harassing nature. And, you know, he's going to get everybody. Like that in and of itself, it's just not believable coming from Brian Albert. There's no way that Brian Albert is going to sell to me that he's worried, genuinely worried about Mr. Carney. Albert felt intimidated and noted that Mr. Carney also addressed him in blogs. However, as echoed in all of the other sections, the actual words spoken were not true threats as required or harassment as defined in O'Brien Supra. Albert testified that at the rally, he was exhorted to tell the truth and was told that he is lying. Mr. Carney never told Albert to tell the truth, but rather addressed the audience and brought awareness to Albert's involvement in the John O'Keefe murder. None of the recorded statements involving Brian Albert at the rally can be divorced of their First Amendment protection and reasonably be construed as threats or fighting words where such protected, pure, non-criminal speech is the only reported basis. The First Amendment bars the state from criminalizing such speech, regardless of the hurt feelings of the alleged witness or his family. And this just goes on and on of kind of the same repeated stuff here. And then we get to old Juliana, the refrigerator Nagel. Ms. Nagel was presented at 34 Fairview Road the night of Mr. O'Keefe's death. She initially admitted to seeing a dark figure, a black blob, on the Albert lawn. Her involvement in the case was addressed at the July rolling rally in the neighborhood. Like Brian Albert, Ms. Nagel parroted all of the conclusory keywords in the statute. She claimed, Mr. Carney harassed me at my residence. He was very intimidating. I was harassed. Yet, when the underlying words and the statements and video are analyzed, there are no threats or fighting words, only expressions that there is a cover-up that Ms. Nagel should come out and tell the truth. The prosecutor again elicits opinion testimony. Question: so in your opinion, is he insinuating that you lied about this? Her answer: yes. He thinks that, yes. Question: in your opinion, is he trying to get you to change your testimony? Yes, correct. Only in the prosecutor's Kafkaesque worldview can telling a witness the truth be a felony. In reality, where there are no threats or fighting words, protected speech cannot be characterized as a crime. It is not evidence or unlawful intent absence, such evidence, blah, 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 blah. So, yeah, I mean, and let's look at that again. Let's read between the lines here, folks. Right? There are no fighting words, only expression that there is a cover-up. In your opinion, is he insinuating that you lied about this? And she says, yes, he thinks that, yes. Right? So these little things indicate that these people are more interested in protecting themselves and more interested in being seen as truthful people rather than convincing whoever the powers that be are that Aiden Carney is actually a threat to them. That takes a back seat in the Econoline van. A back seat to what you can see they're worried about. They're not worried about convincing a grand jury that Aiden Carney is dangerous. They're not interested in convincing a grand jury that Aiden Carney is a threat to them. They're interested in the grand jury, irrelevant to this case, feeling like they're truthful people. That is very telling. That's something that I don't know a liar might do, who's trying to convince people that they're truthful. Because if you were so truthful, you would be pointing out reasons why Aiden Carney is somehow a threat to you. And your feelings being hurt doesn't count. Now we move on to Chris Albert. Chris Albert in this section here and after is a Canton Town selectman, the father of Colin Albert and the brother of Brian Albert. Albert was out drinking at Canton bars with the group that later left and went to Brian Albert's home on the evening of Mr. O'Keefe's death at 34 Fairview. Albert did not go in his brother's home that evening. Mr. Carney has been reporting on Albert, urging him to come clean with the full story of his family's involvement in the death of John O'Keefe. Mr. Carney reports and believes Albert is complicit in the cover-up. Mr. Carney notes to his listeners that Colin Albert appears to have received special treatment from investigators and that he has a long-standing family relationship with Trooper Proctor and or Proctor's family, which would constitute an obvious conflict of interest. Of further public concern is the status of Albert as a Canton selectman and the brother of a Canton police officer being Kevin Albert. Albert also owns a pizza shop in downtown Canton. Mr. Carney has protested and raised awareness in downtown Canton and then reports on his findings on his live show and other online outlets. See generally December 14th, 2023, grand jury transcript. Mr. Carney is charged with one count of witness intimidation involving Albert. So just to illustrate a little bit, Turtleboy is charged with witness intimidation because he's harassing. So he's and harassment because he's picketing outside of D&E Pizza. Right now, here's an interesting thing. Can you charge somebody with a crime if they stand outside of a KFC? Right? If they stand outside of a KFC and stand out there naked, screaming and yelling, chickens are being mistreated. Right? Now, the reason I use this as an example is because this is a common practice by PETA people. I know this to be a fact. PETA people will do what they like to call demos, where they get buck naked and they stand outside of a KFC and they pour red paint on themselves to indicate blood and murder and right? But you can't arrest them. They're exercising their First Amendment rights. You could stand outside of D&E Pizza and straight up say, hey, there's blood in the pizza. Even though it's metaphorical, it comes off pretty literal, right? Somebody could construe that and go, oh my God, they put blood in the pizza? Oh, I'm not eating there. But that's not illegal. Affecting someone's income is not illegal. If your speech affects someone's wallet, that is not illegal. But you might be able to take civil action against them, but you cannot charge them with a crime. Now, there might be grounds to sue Turtleboy on Chris Albert's part. Maybe, not a lawyer. But he didn't commit a crime. It's not a jailable offense. It's not even a finable offense. Not as far as the Constitution goes. Not as far as the First Amendment dictates. Albert testified that Mr. Carney called him and his wife in an effort to ask them questions about the Reed case. And he went to his pizza shop to speak with him. Albert, trying mightily to touch on all the key words such as harassment, intimidation, economic hardship, alleged action of others, minions, as referenced by the prosecutor and the like, Albert was still unable to provide any evidence of true threats or fighting words employed by Mr. Carney. Instead, the testimony and video show Mr. Carney again practice his protected mix of dogged investigative journalism, advocacy, pointed political hyperbole, satire, and opinion. Albert's exaggerated claims that Mr. Carney followed him, confronted him, called his phone, showed up at public meetings, etc., are normal protected things that journalists do to try to extract answers from difficult persons of interest and public concern, in which he didn't even really do all that. Who they believe are hiding something or advantaging themselves through their privileged positions. None of the episodes related by Albert resulted in a police action or arrest, even ignoring the fact that non-criminal speech is protected, even if it causes economic or emotional harm, which illustrates my point, which spells out my point that I just made. Albert's testimony is speculative and insufficient. It is also blatantly misleading in parts. He is specifically asked by a grand juror after his testimony on the summer 2023 activity, did they advise you to file any kind of harassment order or anything like that? Albert replied, no, not at that particular time, no. Albert, in fact, did apply for harassment order against Mr. Carney on September 28th, 2023. In the Stoughton court, and like Jennifer McCabe, was rejected on First Amendment grounds. If the grand jury received the truthful answer that the conduct aired out before the body was previously found by a judge to be protected conduct, it is likely that no indictments would have issued for all of the categorically similar conduct presented as to all of the alleged victims. Albert's misrepresentation went entirely ignored and uncorrected by the prosecutor. The indictment should be dismissed for this misrepresentation and the following government inaction on their own. Adding Jennifer McCabe's unsuccessful undisclosed attempt for an order from Stoughton that was also denied on First Amendment grounds removes all doubt as to the course of action. Albert also complained of economic harm and, armed only with pure speculation, tried to pin it on Mr. Carney. There is no evidence Mr. Carney told anyone to bother Albert or do anything to affect his business. The only evidence involves Mr. Carney advising someone to not eat or boycott Albert's Pizza due to Carney's view of the lack of cooperation and truth-telling in the Reed case. Again, that's protected under the First Amendment. I could straight up sit here right now. As a matter of fact, I'll fucking do it. I don't think that you should eat at D&E Pizza as a protest. You should boycott D&E Pizza as a protest to encourage Chris Albert to tell the truth and and disclose his knowledge, his true knowledge of what happened to Boston police officer John O'Keefe on the early morning hours of January 29, 2022. I'll say it. On those grounds, I feel like you should not eat D&E Pizza. I can absolutely do that. Go fuck yourself, Commonwealth of Massachusetts, if you try to charge me with it. Go fuck yourself. Fuck Chris Albert. Fuck D&E Pizza. I don't think you should eat there because I think Chris Albert knows a lot more about John O'Keefe's death than he is alluding to. Period. Fuck D&E Pizza. Don't eat that shit. Don't eat that shit. Because the dude abuses his power as a selectman to influence. I have that belief. I believe that shit. I believe he abuses his power as a selectman and his influence with Michael Morrissey to make things happen. I know this to be a fact, as a matter of fact, because Ken Mello weaponized Chapter 28, 13A and 13B against the Canton Nine. And we heard a recording of Ken Mello telling a sergeant of the Canton Police Department to weaponize this law to charge those people. And how did this happen? The only way this happened is if Ken Mello got a call directly from Chris Albert, because it was Ken Mello who reported the issue to the Canton Police. Why didn't Chris Albert go straight to the Canton Police? Because he felt that his influence, he knew that he had more reach. Why am I going to go through and sit in the line? Why am I going to go through the front door like everybody else when I got backstage passes? I got access backstage. I'm Chris Albert. I can go straight to Ken Mello and make him do my dirty work for me. So based on that, I say boycott D&E Pizza. Charge me with something. Am I committing a crime by encouraging a boycott? This activity and the supposed attendant economic harm inflicted is a constitutionally protected boycott as set forth in the NAACP versus Claiborne Hardware Supra, which established conclusively that the right to boycott for First Amendment purposes that states cannot prohibit peaceful advocacy of a politically motivated boycott. There you go. I think Chris Albert is a fucking Democrat. Don't eat at D&E Pizza. Charge me. I dare you. Charge me. Charge me with a crime. Ironically, the only actual evidence of economic harm to the pizza business comes from Albert's testimony on his own actions, turning away anyone who appears to be a Reed supporter and refusing to serve them. Great point. I love that they pointed that out. So if you're hurting so bad, you'll serve fucking anybody, dude. You're not going to get, if you're financially hurting so bad, you don't have the luxury to pick and choose your customer and refuse service to people because of the t-shirt they're wearing, because of the color of their shirt happens to be pink. You don't get to do that. If you're so fucking, if you're hurting so bad and your business is hurting so bad, you're going to take any business you can get. Fucking homeboy rolling in there dressed like a fucking rubber ducky comes in with green money and says, I need a fucking mediocre chicken parm, please. You're going to fucking make that sale. You're going to take every bit. You don't get to complain about your business not flourishing if you're not taking every single fucking order. If you're refusing business, that's on you. Yes, soon, Robin G. Yes, for sure. Soon. We will do that. Thank you. Think about that shit. Like, you don't get to whine and bitch about business being slow when you're turning away customers. That wouldn't even stand in civil court. That right there should be enough in theory to win Turtleboy's civil case if Chris Albert tries to sue him for it. If Chris Albert tries to say, okay, well, I can't have him criminally charged. You walked on the criminal charges. I'm going to sue him because he cost me business. He cost my pizza business income. Well, then Turtleboy could turn around and argue and go, no, man, you did that shit to yourself because you turned away people with fucking pink shirts. The fuck does somebody's colored shirt have to do with whether or not you fucking are able to fucking meet your overhead? Fuck you. Which is another indication to me as to why I don't believe that Chris Albert depends on the income that D&E Pizza makes. I don't think that he depends on the profits of D&E Pizza. I just simply don't. Because there is nothing, and I could go on a whole rant about it because I've done it many, many times already. But based on the employment as well as the image and appearance of Jim Ferris, that alone tells me that Chris Albert does not give a fuck about the sales at his restaurant. I could still use that. If I was defending Turtleboy in a civil trial, I would point all that shit out. I would be like, is this I'd show a picture of Jim Ferris's fucking shirt from his nipples down to his crotch, and you're just going to see a bunch of fucking dirt and grime right here, showing him smoking cigarettes. Read reviews of people fucking talking about that he shows up to their fucking house delivering food, smelling and stinking like cigarettes and ass. Like that alone, just Jim Ferris alone would be enough to argue, much less the image of his store, the cleanliness of it. Like that would be enough for me to be like, dude, I'm not hurting your business. How can you tell me that I'm hurting your business when you are showing your own customers that you don't even give a fuck about your business? The way you conduct your business indicates to your customers that you don't give a fuck about it. And you want to convince a judge? Case dismissed. That's it. That's how it would go. You want to convince a judge? Case dismissed. It's all over. Dude, and I could go on and on. I can go on and on about D&E Pizza and just what I fucking seen from video footage of the outside of it. Just the outside of that fucking place. I could go on and on. That would indicate that this dude does not depend on the income of D&E Pizza to live. Albert's testimony on his own actions, turning away anyone who appears to be a Reed supporter, refusing to serve them. Albert's self-inflicted wound has nothing to do with Mr. Carney's advocacy or journalism. The Commonwealth's economic harms stricture is unconstitutional, and the charge must be dismissed. And then we got Bukkake. Trooper Buchanan is a supervisor on the Karen Reed case state police team. He oversees Trooper Proctor and was himself punished for condoning and covering up Proctor's misconduct in the Reed case as set forth supra. He has been on the DA's detective unit for almost 10 years. Buchanan alleges that on September 15, 2023, he was a victim of witness intimidation by Mr. Carney. Buchanan complains that on the public street outside of the Norfolk Superior Court, Mr. Carney asked him questions and he was badgered with insults on his way to the police car. And yeah, basically it's just Aiden going, "You're a fucking loser. You're a loser." You call yourself a cop? That kind of shit. That's not illegal. That's him expressing his opinion. That's him expressing his opinion. He's allowed to fucking do that. You're a fucking cop and you're a fucking you're shitty at your fucking job. And I think you're fucking dirty. That is perfectly within Aiden Carney's rights. Buchanan then reports interactions with third parties that upset him, where he and the prosecutor again create the implicit suggestion that Mr. Carney should be held responsible criminally for this discomfort. Here, the familiar refrain in the instant memorandum again applies. Mr. Carney's speech is protected as non-criminal First Amendment expression on matters of public concern. Expressions of disapproval of the police are protected under the First Amendment, and name-calling certainly qualifies as such. In fact, the oft-cited herein O'Brien versus Borowski case, Supra, is famous as the case that makes it clear that it is constitutionally protected speech to give the finger to a police officer without criminal consequences, so long as there are no accompanying actions or other criminal utterances that can create a true threat situation. As in O'Brien, Mr. Carney spoke disapproval to Trooper Buchanan concerning malfeasance in his official duties and also questioned him regarding an unaccounted for Ford Edge vehicle seen outside of the Albert house late at night by the plow driver, Lucky Lafren. The encounter was in public and played out in front of several state troopers doing guard duty on the crowd, as mentioned by Buchanan, and none reacted, intervened, and certainly didn't arrest Mr. Carney for this supposed witness intimidation. Now, just to illustrate that again, and let me put that into other words. So when he was putting a phone in Bukkake's face, calling him Bukkake, calling him a loser, asking him where the fuck is the Ford Edge. He was surrounded by other cops. So if Carney was breaking the law, why didn't anybody arrest him? If Turtleboy was breaking the law, if he was harassing, why didn't any of those state troopers or whatever police department intervene and go, okay, you're under arrest? Why didn't any of these people go and leap forward in protection of their brother in blue? Why weren't they concerned for his well-being? Why weren't any of these cops concerned for Bukkake's well-being? You know why? Because those cops didn't think that his well-being was in danger. Simple. They didn't feel he was being threatened. Simple. Because if they felt that he was being threatened in any way, shape, or form, you don't think that any of those cops would have arrested Aiden Carney in order to protect their brother in blue from this threatening, intimidating figure? Why didn't it happen? And it's simple. Like I said, because none of those cops felt that Bukkake was in danger, or any of themselves for that matter were in danger. They didn't see Turtleboy as a threat. So how can you claim later that a bunch of cops who know the law, how can you claim later that this is a point of those charges being valid? That this is an incident to be cited? Why? How? This is because even inexperienced highway state troopers guarding the courthouse know that such an encounter is protected speech. Exactly what I just said in better words. Better words, better row, better. Okay. Lacks true threats or fighting words and cannot solely be found to be witness intimidation. The Bukkake indictment brought in bad faith with anti-constitutional motives, lacks probable cause, and must fail, my friends. It must fail. For the foregoing reasons, the indictments lack probable cause and were the product of an irredeemably impaired presentation by the district attorney. All of the charges must be dismissed. And there you go, folks. We'll see what happens here, because at least it's not Judge Bev that's presiding over the case. What? He said I was a cunt. No. I hear that he's running for Canton Selectman. I'll be sure to cast in my vote for Chris Albert. I'm kidding, folks. I'm kidding. I can't cast my vote for Chris Albert because I'm not registered to vote in Massachusetts. But no. I'm kidding. Even though there's no secret about my feelings about Crawford. I officially endorse Mike Crawford as a Canton Selectman. I officially endorse Mike Crawford as Canton Selectman. I want that on the record. But yeah, man, that wraps that up. That didn't take as long as I thought it would, actually. But I appreciate all you guys hanging out with me, man. I had a great time. Thanks for hanging out with me. And let me go over real quick. I think I got some donos, bro. Some donos. And make sure, if you're feeling generous, Turtleboy could use some help with his legal defense as well. And his link is pinned to the pinned to the top of the chat. Chop of the tat. So let me see here real quick. Okay, that's weird. What in the hell? What in the hell? Okay. So let's see here. Okay, I got a couple of Venmos. Teresa says shenanigans and stuff. Thank you so much. And Sandy says, I am old and you make me laugh my ass off. I love it. I'm old too, man. I still laugh my ass off. You gotta laugh. You gotta laugh. You gotta have fun, man. And let's see. Lola, wait, we gotta do it one more time. We gotta have it one more time. I mean, it's only right.
Oh, here we go.
I think we got a super cat. Super fan. I think we got a super cat. Super fan. Super cat. Super fan. 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 I think we got a super cat.
How dare you?
Lola the good dog, thank you so much. Will, have yourself a slice of hot apple better pie with a spicy scoop of cinnamon ice cream on me. Love you. Love you too. Decline, thank you so much. Thank you, Will, for all you do. Thank you. I appreciate you a lot. Yeah, no, the motion, I saw somebody just asked about that. I don't think that the motion is available yet. All that's available is that it was filed, but I don't think that the motion itself is available yet. If it is, I'll go over it tomorrow. And I'm just missing it. I'll go over it tomorrow. If not, when it comes out Monday, I'll go over it. But guys, thank you guys so much. Make sure I can't think of the name of his channel and it's driving me crazy. But Andrew Meyer and Laney Law, they're absolutely awesome, and they hosted me in a pre-recorded video discussing the most recent filings, and I really enjoyed the conversation. I look forward to collabing with them in the future. I'll allow it. No one else I'd rather spend Valentine's Day with. Awesome, thank you so much, appreciate that. So yeah, guys, if you're new subscribers, thank you for subscribing. I hope you guys enjoy the channel moving forward. And if you guys please take a moment and hit the like, it would really mean the world to me. It really helps out. And guys, all of the support, thank you guys so much. It really, really, really means the world to me. Yeah, you guys are just so awesome. But I am going to go ahead and wrap this one up. Free Turtleboy, free Karen Reed, folks. We got to do it. Free Turtleboy, free Karen Reed. Guys, I love you very much, and we will do this again very soon, my friends.